Okay, I suggest we start. Anybody who's arriving late can always join us. So good morning, everybody. My name is Marko Schillinger from consulting company Divolve, and I would like to welcome you to this second workshop after the first one, which was held in Zagreb. This time we are online, the second workshop of the project Enhancing Opportunities for All. The project is funded by the European Union within the European Defense Fund. And our topic today is intellectual property rights. The experts that will guide us through this complex topic are Ms. Maja Borić-Vezjak and Mr. Aleš Lipnik. But before we get started, just also a quick reminder that this workshop is being recorded for the purposes of archive and EU documentation. But before we get started with the workshop, I would like to ask Bruno Grubišić, the representative of Croatian Defense Industry Competitiveness Cluster, to say a few introductory words. Bruno? And yes, just to answer this quick question, we will share the PowerPoint after the workshop. Bruno?
Thank you, Marko. For those of you who didn't meet me or don't know, my name is Bruno. I'm employed by CDICC as a project manager for the EOA project. I will be replacing Mr. Božo Miletić from this month, actually. So this is my let's say first time. So I'm fresh new face for maybe some of you. I want to apologize for Goran missing this online workshop because we planned to have him this morning for an introduction. Unfortunately, he had other obligations with the Ministry of Defense this morning, so he couldn't be available with us. Anyway, Marko said everything that is important for this training. I want to thank you all for joining us, and I wish us all a good training and there's a lot of things to learn, and I hope you will enjoy it and ask some questions because Aleš and Maja really have a lot of experience on this topic. Thank you all, and enjoy your day.
Aleš, Maja, the floor is yours.
Thank you very much.
Thank you. And good morning to everybody.
Can you hear us? Is it okay?
Yes.
Okay, perfect. So let's start.
Maja, your microphone is off.
Sorry about that.
Okay.
Good morning, everybody. My name is Maja Borić-Vezjak, and I'm a Slovenian and European patent attorney. I work every day in our company, Patentni Biro AF, which was established by my mother, who is also a Slovenian and European patent attorney. So I had the privilege to grow up in the environment conscious about intellectual property, and I'm really excited to be able to present to you today some introductory things about intellectual property and particularly regarding patenting.
Okay, and my name is Aleš Lipnik. Some of you already met me in Zagreb session we have in February. So I derived from the university as the head of Technology Transfer Office, where I work for 20 years. Now I'm running my own company, Do It Right Solutions, which is oriented toward helping the companies for growth and scale up. I work a lot also in the EU defense programs, in EDF, as a coach and evaluator, as well as Diana Accelerator and EUDIS Accelerator, as let me say, other instruments which are oriented toward defense industry. So this is short presentation, and I hope you will enjoy our today meetings, let me say, or workshop. Yeah.
Maya, your microphone is again off.
Okay.
Sorry, it keeps turning off because we have to move the slides. Today's presentation will be divided into parts. The first part will be before lunch and the second part after it. In the first part, we will go through the introduction of the intellectual property and the overview of IP rights. We will discuss some things particular for the defense sector and go through patenting and infringement of patents. In the second part, Aleš will be talking most of the time about various aspects in international projects, in consortium agreements, in various strategies for the EDF partners and compliance with other directives and regulations, which are also important in IP as well as in use of IP rights. Short overview. So the first part before the break will be the introduction into intellectual property in general, and then we will address patenting and various aspects. So the discussion is planned after the second part, but please feel free to ask questions in the chat at any time. We will monitor the questions and try to answer them as they are made, but probably some of those questions will have to be answered in the discussion session. So please feel free to ask anything. We will do our best and try to answer all of them. And if there is something else after the meeting or the presentation, we can discuss that later in the afternoon. I should want to say something about the third part.
Well, as first part is more or less oriented toward intellectual properties in general, third and fourth part will be more oriented toward IPR connected within the international projects, especially, of course, with the orientation to EDF. So this part will be more, let me say, EDF oriented. And as Maya already said, discussion, it's always welcome. You can also do this by raise a hand, and we can try to clarify something immediately during our presentation, or we have separate discussion slots at the end of our presentations. And as well as Maya already said, we also can use chat as a tool for setting the questions and answering.
Okay, so let's start. I don't know how many of you have crossed the term of intellectual property and what you know about it, but we have to first answer the question, what is intellectual property? And to do that, we have to go into history, not a few decades ago, but several centuries ago. Before a common era in a Greek state called Sybaris, there was the first law that we consider as an intellectual property law. And this Greek state is nowadays located in Calabria, in Italy. And there was this possibility for the chefs and certain people that develop new inventions in the term of luxury and in terms of culinary delights, they were able to protect their recipe for 1 year. So 1 year was the monopole period in which their recipe could only be used by the developers, so the chefs. This was the first kind of law that was discovered. As you see, there is a lot of gap between the Sybaris and the Republic of Venice Act, which indicates that maybe something was not going on in this period, but maybe we haven't discovered yet any other law. But nevertheless, it was considered for a long time that the Republic of Venice was the first state to make an act regarding patenting. So the Republic of Venice required the registration of new inventions, and they protected those inventions from counterfeiting. And the rules basically that the statute provided was that the patents may be granted for any new and ingenious device that was not previously made. And this general rule is still active in nowadays patent acts and laws all over the world. So this was really the stone that marked the development of IP and IP protection. Between the establishment of this act and in the following 14, 15 years, the Venetian Senate granted about 2,000 patents, which is really a lot. But the reason behind the large patenting activity was that everything was free. So there were no fees to be paid, and the people of the Republic were encouraged to file patents. Then for some time, nothing really happened in the terms of IP and IP protection. And then there was in 1710, the Statute of Anne in Great Britain. And this is considered the first copyright law that was enacted anywhere in the world. So before this statute, there was some discussion about the protection of copyrights, what rights the publishers have, the acts of restrictions and monopoly over printed books and works. And this was an ongoing battle between the publishers and the parliament. And eventually in 1710, the Statute of Anne, which is named after the Queen Anne, which was reigning then, was set up in order to define that there is protection of any book already in print or to be printed for at least 21 years. So this was the first Copyright Act in the world. Later on, many states followed with their own IP laws, and there was Austria, Russia, Belgium, Bavaria, Sweden that were following the Statute of Anne and the Republic of Venice ideas, and there was patenting laws emerging everywhere around the world. But those acts were not harmonized, so every country has its own rule, and there was an attempt to harmonize the landscape of IP, and it was finally set in stone by the Paris Convention in 1883. And it applies to the whole industrial property sector. So in the widest sense, there are patents, trademarks, designs, utility models, trade names, geographical indications. Everything is covered by the Paris Convention. And the important rules that were set in Paris Convention are still valid now. Most importantly, each contracting state of the Paris Convention has to treat everybody, so any applicant, in the same way as they would do their own nationals. And also there was an establishment about the priority. So if you file a first application in any state, you still have the priority to file it elsewhere. And it depends on the right to which it applies. So we have 6 months for the trademarks and designs and 12 months for patents. After the Paris Convention, of course, the law evolved again, and in 1973, European Patent Convention was signed, and it provides a legal framework for granting European patents. So this is a harmonized procedure in front of the European Patent Office, and this is widely used today. I'm certain that a lot of people may have heard about this, and it is something that I do every day. So there were different things mentioned, like patents, copyrights, and recipes, but this is only a part of the intellectual property. So according to the WIPO, so the World Intellectual Property Office, the term intellectual property covers the following: the creations of the mind, such as inventions, and those can be patented. We have literary and artistic works, which are protected by copyright. We then have designs, and you can easily spot their specific shape, and symbols, names, and images used in commerce. So Coca-Cola, Lego bricks, there are known things that are actually IP rights. In overview, we can go to the next slide. We divide the intellectual property into three different parts. So the first part is copyright. It, as already said, protects literary works, artistic works, but also industrial design, architectural designs, and so on. Music, which is an important part of copyright. Then we have geographical indications. These rights are for products that are characteristic due to the place of origin, the conditions for growth, the production, or the methods employed to make them. So the geographical indications are, as you've noticed, the feta cheese can be used only by the real producers of feta and Grana Padano and Parmigiano Reggiano and so on. So these are the geographical indications that protect the origin of the product or the service. The third part is industrial property, which is further divided into patents, designs, and trademarks. So the patents protect technical solutions, so inventions. Designs protect the shapes, the visual appearance of the products as they are being sold or present in the market. And then we have trademarks, so logos, names, also 3D designs, sound, for example, for radio jingles and so on. So this is a really wide variety of rights that can be protected. And each of these rights has a separate and individual application, because if you file a patent application, there is no automatic design registered or a trademark registered. You have to file separate applications in order to get the rights granted. So at the end, you arrive at separate, distinct rights, which my mother considers as a house. You know, if you have a patent, you have a house. You can then treat it like property, you can sell it, you can license it, and so on. So every right, patent, design, trademarks, they represent their own house, their own property. But as you can, as you can imagine, those rights are not just exclusive. They can be different aspects to one invention or one solution. For example, if we have a company name, the suitable IP right is a trademark. But then if we have a new antibiotic compound, we can patent it because it may be a new compound or a new method of producing that compound or a new administration protocol that can be patented. But on the other hand, we can also protect the name of the antibiotic compound, and this will be done with a trademark registration. And there are further examples that I prepared just to illustrate the IP rights. there is new principle of thermal vision, for example, and we can have a patent on it. We can also have a design registered for the appearance of the device for thermal vision. So if we have specific goggles or specific cameras that can be used, they can be also protected with the design. And there also can be a copyright for the industrial design of the device itself or for the method of the thermal vision. So the computer programs are protected by copyright, which is an important thing that has to be kept in mind. The website contents are protected by copyrights. This is something that is automatically valid for websites. So you may notice the circle, usually somewhere on the website, usually really downstairs if you scroll it down. There are new methods for determining particles in the air, and similarly as for the principle of thermal vision, we can have a patent on it or have a copyright for the computer program monitoring the methods of the determination of which particles are present in the air and which are not. So this is something that is coming into play more and more because we are being more conscious about the environment, about the particles in the air. We monitor a lot, and the new acts and regulations pose new needs for determination for the following of particles in the air. So this is something that is really evolving field in terms of IP. Then we can have special shapes for rifle holders. There can be patents on it, designs, again, copyright. And if we move further, then we have new product name. And as you can imagine, there's a trademark right to the name. If we have a product packaging, again, it can be patented. We can have a design for the package visual appearance, or again, a copyright if it's something that we will not design or patent. Computer programs per se are not patentable, but they can be patented if they have a technical effect. So this is something that's been going on now for decades, and it's an interesting topic which can also make sense in the defense sector, of course. If you considered windshield wipers on your car and how they automatically operate when rain is sensed. So this is governed by a computer program. And at first this was patented, but it was refused. The IP office, the patent office said, you know, this is a computer program, it cannot be patented. But the applicant was stubborn and they said, no, this computer program is only assisting in decision whether the wipers have to clean the windshield and how fast they should do it. And this is done on the basis of the sensors. The sensors sense the amount of droplets on the windshield, and based on that, the computer program decides whether to activate the wipers or not. So in the end, this formed the basis for the computer program protection, also by patents. And in defense sector, you could anticipate that some programs may also obtain patents. For example, if there is an interaction between some technical features and the computer program, and then a decision is reached or a recognition is done or comparison and so on. So this can be used in surveillance or different kinds of activities, and therefore computer programs can also be patented. However, the copyright is always active on computer programs. There is no specific registration process to get the copyright active, but it is advised to do it with a national authority for copyright grant, because if there is a need to use those rights in court, then some of the courts need this certification that the copyright is protected. As you can see, there are certain overlaps between the rights, and the first one is, as I've mentioned, between the patents and copyrights. So a computer implemented method can be patented if it includes novel and non-obvious technological processes. The source code and the user interface, of course, are protected by the copyright. Something that is getting more and more interesting, and also numerous cases are now at the patent offices because there is an emerging field of artificial intelligence, and more methods are being governed by computer programs and also artificial intelligence. So this is an evolving field in the patenting and intellectual property landscape. Then we have the trademarks and the shape of goods. For example, this is a typical case of Toblerone. I'm sure that everybody is aware of the chocolate that's basically triangular, and this chocolate bar is protected as a trademark and as a registered design. So if someone was to produce chocolate in the shape of a triangle, then Toblerone could oppose such use. But in essence, the shape of goods is protected by design and the name is protected by trademark. Then we have an overlap between the designs and the patents. So designs can be used as a supplementary protection for some patented inventions. And this is most commonly relating to some embodiments that are special in their design. And what the inventors sometimes do is they file a patent application for the technical solution as such. And the patenting process, as you will see later on, it takes some time, and it consumes also a lot of energy and financial investments. So designs is kind of a highway or a short way to get something registered and some rights active. And what after patenting happens, then the inventor says, okay, this specific shape is also characteristic sufficiently to be protected by design. And then we file a design application, include the figures of the product and protect them. So this is, for example, I've had a case with wind turbines. There was a specific shape of the blades, and we filed patent application for it, and also design for the specific shape of the blades and the whole turbine as such. Then we have an important overlap between patents and trade secrets. So the patents become public. When you file a patent application, you get processed, but in the end it will become public. Sometimes the inventors feel like keeping the secret would be better or would be beneficial for their business. And the trade secrets do just that. They include the confidential business information, and this secret can provide a competitive edge. For example, if there are some certain formulas or practices or designs, and particularly this is valid for specific preferred embodiments of invention. So what may happen is that a patent application is filed for a general solution, but the best working embodiments are kept secret, and these are the know-how of the company or the inventor, and the trade secrets are never disclosed to the public, and they can last indefinitely. So as long as they remain confidential, the competition will not know what the specific formula or specific best embodiment is. I've seen this, for example, in some jewelry making companies. There's a company in Vienna making enamel jewelry, and basically since 1951 or 55, when they were established, nobody was able to recreate their process, and it comprises more than 200 steps of mixing the powder and heating it and burning it and so on. So it's a really complicated method, that the company decided to keep secret. If they were to file a patent application, it would become public, and after 20 years, it would become general knowledge and everybody could use it. So they made the wise decision to keep their specific method secret, and no one in the world was ever able to recreate their own method and to have the same kind of quality and jewelry in the market. So this is something that may come up also in the defense sector. There may be some inventions that are possibly better to be kept secret. And when this is relevant, the trade secrets are basically protected by making the description in a similar way as a patent application, but those are kept secret. They are classified inside a company, and they are only disclosed when needed and upon signature of certain agreements that pose secrecy on those who are receiving the information.
Yes, maybe I could add just a word regarding that. Yes, it's important, especially in defense sector, that we are aware that when we are filing a patent, we actually open our invention. So it's described and it's published and it's public available in the patent databases. So we will talk about this later on. However, trade secrets in this point, it's, let me say, fair, and maybe in the defense sector also very effective way to protect its intellectual rights. Okay.
Yeah, so last of all, we have copyrights and trade secrets. We can also overlap. Again, the trade secrets can involve software or algorithms, and if an algorithm is kept secret, it is protected under the trade secret law. If it's later published or shared, then it may be protected by copyright. But again, we have this determination whether we have to disclose it to the public or whether we would like to keep it secret. This depends on the invention or the solution or the target use. So when faced with a possible selection of rights, it also has to be considered what kind of protection do we want and what it achieves. So this is a really delicate matter. I think that Aleš will agree with me that a lot of discussion has to take place in order to decide which path is the best way to go in terms of getting a competition edge or to prevent secrecy or to establish a monopoly in the territory that is desired. Do you think we should add anything?
Maybe later on we will talk in the afternoon session. We will talk also something about that.
Okay, so if we protect the IP rights that we saw, so the patents, copyright, trademarks, designs, and so on, the owner gets specific rights. And the most important is that the owner may prohibit the commercial exploitation of the subject matter of the right for which he is not given permission. So if we have an invention that is patented, the owner can prohibit everybody else from using his invention or their invention. And this is the sort of right that excludes everybody else from use. And if the third parties are not considering a license and they use the patented invention nevertheless, the owner may take a legal action against everybody who uses their invention or trademark or design or copyright. So the owner can take the third party into court.
Maybe I will just add here, the owner have to take legal actions, because then nobody else will take any legal actions. except owner, if there was some exploitation without given permission from the side of owner. So there is no legal action per se from the, I don't know, patent office or national office or something like this. The owner is only who have to take these legal actions. Sorry.
Yeah, no, it's a really good point. However, if there is a licensing agreement in place for a specific IP right, then it is also the licensee sometimes who can make the legal action, but this depends on the agreement between the owner and the licensee. But nevertheless, it is important to note that the protection of these rights relates exclusively to economic activity. So if the invention is used in, for example, in a lab for testing, this is not considered an economic activity. If I, make a device according to a patent for home use, it is also not an economic activity. So we only can take legal action when economic activity is in place. So when someone is gaining financial benefit from the invention. The rights of the IP are territorial, so they are valid in the territory where the protection was granted. The only exception is copyright, which is valid worldwide. But for patents, designs, and trademarks, the rights are territorial. So if you have a patent granted in Europe, but non-patent granted in the US, for example, you are free to use the invention in the US as long as the products do not reach Europe. Also, the rights are limited in time. The patents are maximally valid for 20 years, unless they are patenting or protecting an invention that has to be granted further certifications, such as medicines or herbicides or biocides and so on. Those rights can then be extended for 5 more years if supplementary protection certificates are in place. For trademarks, the protection is indefinite or can be indefinite. A trademark is valid for 10 years and they can be renewed every 10 years for an unlimited number of times. So eventually, if the owner of a trademark is interested in having the trademark protected, they can renew it for an indefinite number of time. The designs are maximally valid for 25 years, but those have to be renewed every 5 years. So there are specific regulations and differences between the duration of the rights, but in any case, patents are limited for 20 years.
I have one question, actually, regarding, you said that the copyrights are territorially worldwide oriented. What about the space? For example, if we have some software using on the moon space station, which is out of the Earth, do we have some legislation regarding that, or?
To be honest, I'm not really sure about space. I know that there have been considerations about those aspects, but copyright is something that is handled by other offices and other persons. Patent attorneys rarely cross paths with copyright. And even when we do, we usually direct people to other institutes.
Okay.
But regardless, there is a certain vision for rights. If we have something in space and it's being used in space, it had to come up from the Earth upstairs into the space. So at certain point, there was use on Earth, and in that regard, it was used in a territory that can be defined and is in place. But yeah, the copyright is essentially what a right that's valid worldwide, but also has its own constraints. And if you are going to use copyright in court, some courts may need a special certification, or the rights can end, because they are only valid for 19 years after. So there may be certain aspects in copyright that we will not go into because they are a world on their own. So I think that for the audience today, this information is quite sufficient, but if someone has any further questions, feel free to ask.
Okay, I just get in mind when we talk about that. Yes, thank you.
Yeah, so if we consider the intellectual property protection and obtaining some rights, we have to do it in order to get some benefits. And these are multifaceted, they can be for the company or the inventor, the owner of the rights. It can be, for the community or the field in terms of collaborations and so on. And also the benefits may be reflected in the general public. So these benefits are given based on the experience that we had with our clients, and this is something that sums up the benefits for the company or the inventor. So this is prevention of counterfeiting, the ensuring of quality of products, preventing confusion in the marketplace, and enabling financing options and boosting the business growth. What has to be borne in mind is that if you have a patented invention and the product is eventually in the market, it will have a competitive edge over the competitors. And if you are able to prevent any counterfeiting, then you are gaining more and more financial benefits from the sold products. And in this case, you can grow as a business, and you can also obtain some further financing, or you can obtain some possibilities in projects, or you can get reference in order to collaborate with other companies and so on. So in terms of collaboration, the protected IP is an asset in forming joint ventures. It can be either with home companies, so in the home soil, or with foreign companies. There can be collaborative projects and securing financing. Aleš has a lot of experience in various projects and how to obtain them. So maybe if you can add something on these benefits.
Yeah, we will talk about this later in the afternoon session, but of course, yes, licensing, exclusive or non-exclusive joint ventures, spin-offs, these are all opportunities which help us to make valorization of our intellectual property. We will talk about these opportunities and the ways how to do it later on.
Yeah, for the general public, for example, I see the largest benefit in promoting innovation and putting knowledge into practice. When I was a little girl, my mom, as a patent attorney, of course, noticed everything that is trademarked or designed or registered or patented and so on. And sometimes it was really interesting to go to a shop with her, because she said, okay, this bottle is protected by a design, and this is a trademark that I helped protect. And when she had some interesting inventions, she would discuss them, privately with me, and said, this is a product that we are preparing a patent application for, and when it comes into the market, it will enable people to massage themselves or to improve their rehabilitation process and so on. So there is a lot of general public benefits, because it also helps businesses grow, and the BDP and everything can be promoted and put into a higher level if compared to a state where intellectual property is not recognized or not protected. I also would like to emphasize that not the companies or the general public can make benefit, also the countries can benefit from it. So there was an EU IPO and the EPO study on IP impact, and it was done over a 10-year period. And companies owning IP rights see a large revenue per employee, and they also pay wages that are higher on average than in compared to companies that do not have IP rights. So when they corrected these relevant factors for the country of origin and the size and the sectors of activity, these differences were even more significant. The difference in revenue, for example, was 41% between the IPR owners and the firms without IPR. So this is a really huge impact, which also reflects then on the budget of the companies as well as on the state, the country of where the companies are active. These benefits are particularly striking for the small and medium enterprises, and they achieve a 44% increase over their counterparts which do not protect IP rights. So it is important to emphasize that small and medium enterprises gain significant benefit from protecting their IP, and this is an important consideration also for the defense sector. A lot of inventions are coming from small and medium enterprises, from startups, and from spin-outs or spin-offs, or whatever we call them. So we have to pay extra attention to the activity of those entities. Also, large companies enjoy an increase compared to IP rights, to companies that do not have IP rights protected, but this increase is a bit smaller because the large companies have set up their own systems, they have established routes of making business and so on. So we have to emphasize that small and medium enterprises are those who benefit most. I see that there is
Yes, there is one question in the politics. Can there be secret patents too?
Yes, this is a really question. I will come up to this point a bit later, but I can tell something about it now as well. So patent applications, when they are filed, they're not public. So the patent attorneys and the IP offices know about it. But after 18 months, the patent application gets published, or even the patent gets published in countries where there is no substantive examination. What this means, we will go to next. But for example, some countries have the possibility to keep an invention secret. This is if it relates to a secret invention in terms that it is important for the national security or for any other considerations. The patent office receiving the application can decide that this invention is really important for the national security and it will classify it. So in this regard, we can have a classified patent application that will not become publicly disclosed. Furthermore, there is a possibility in the US to have a patent application prevented from publishing. And this is a patent application that is getting processed, normally as any other application would be processed, but you have to file a request to keep it unpublished. And when the patent office in the US says, okay, we can grant this because it fulfills all the conditions, then you have to decide whether you will go to grant, because at that point it will have to be published, or if you will keep it a secret. So I think that this answers these questions. We can have some secret patents, but we can go into more detail later on. So the impact of intellectual property, to get back on track where we were, the countries may gain benefits as well, as I mentioned. And it may be in the area of strategic sovereignty, and the country can have control over the critical technologies, and this can reduce the dependency on foreign suppliers. The cost efficiency may be improved when there is a control of the costs inside the life cycle or whatever field it may be applicable to. The countries may boost their export potentials, and they can also license their IP rights abroad. So if we have a certain technology that may be used by others, we can, for example, license it for Germany, but keep every country under our own control. Depends on, of course, the motivation, the bilateral or more lateral agreements, and so on. So this increases the potential of collaboration, as I've already said, and also the exports. It can also boost the small and medium business sector, and these entities basically present or form the majority of the companies. For example, in smaller countries like Slovenia, I think the small and medium enterprises form 90% of the companies. And it's really important to boost them even more, to be able to grow or to be able to license or sell them. And of course, last but not least, the IP can boost the investments, so either in projects or in private sectors. This depends on what kind of rights we have, but this is something that's really important, and it's coming into play even more. R&D investments are the thing that is keeping the cycle going on, and the more IP is protected, the more likely it is to get further projects and further funding. Alex, anything to add?
That point.
Yeah. So together with Alex, we prepared some cases that are really interesting in terms of IP. This is to illustrate how IP protected rights can be impactful. So there was a Finnish small and medium enterprise that developed anti-jamming GPS algorithm. It was developed during a program, and after securing IP rights, the company licensed the technology to a major aerospace integrator in France and retained the right to exploit it in the civilian drone market. So what the Finnish company managed to do, they protected their innovation from replications by other larger players. They used their IP as leverage to enter a NATO supply chain, and the state, the Finnish state of Finland, gained indirect export income and dual use capability. So this is something that's a positive impact of securing IP rights.
Maybe this is, let me say, clear and simple case. Actually, we have to know that, for example, EDF, which co-finance development or R&D of this some result of the project, do not claim any intellectual property rights regarding that. So all the IPR remain at the inventors. And it was that SME developed by public source this GPS algorithm and license it to the aerospace integrator, which get the right to exploit in the civil drone market. So it's, let me say, simple story without any, let me say, special problems. SME develops and license it to a big integrator and get positive impacts to their growth as well as to the state.
Yeah, so this was a simple case, but the second one is the complete opposite of the first one. So this is something that we don't like to see, to be honest, but it of course sometimes happens. This was a case of unprotected software leaks into a competitor product. And Defense University Consortium in Central Europe developed a novel target recognition AI as a part of a national defense initiative. And the project was published before a patent or copyright claim was filed. So this is a nightmare for, I think, everybody working in the field. And you would be probably surprised by the amount of projects I see leaked into the public before a patent application is filed. So what happened in this case was that months later, a foreign drone company commercialized a nearly identical system. And the impact was that IP was lost and the use is not controlled. There is no royalty income. There is no public funding, that was effective because so many rights were lost due to the leak.
It's always a problem when you're working with the university. Why? Because the researchers live of publishing. And if the, let me say, this product or solutions was published before the patent or copyright claim was filed, they lost this novelty factor, which is the most important. Nothing cannot be published before the patent have to be filed first. If there is publishing before, this patent or patent application lost this novelty. And the researchers are, a lot of time researchers are not aware about this. So when we are working with the university, we have to pay special attention to them, not to forget this, because there was no legal, let me say, possibility to force this non-EU drone company who commercialized this identical system regarding that, because they didn't do nothing wrong. They just take the information which have been publicly available. But impact was quite, let me say, strong or bad. The IP was lost. No possibility to licensing in the future, no royalty. And of course, public funding actually subsides foreign competition, not national or EU competition. So this is a case, maybe takeaway for this is when we are working with, especially with universities and research institutions. I'm coming from the technological TTO office from the university. In general, researchers are not aware about this, and we have to pay a special attention regarding that.
Yes, definitely. Although the knowledge about IP and patenting is improving also in the universities and research institutes, but it is still wise to, remind them that the project is secret and there is no leak or any publication in terms of articles or scientific discussions or even congresses. Do you have a question?
Yeah, we have another comment here. He said, but access rights, for example, for governments are somehow recognized on the ministries of defense by default, since they co-found, aren't they? Maybe this is reflected to my questions, or to my claim that, for example, EDF do not claim any IPR from the results of the project. Not claim IPR. Of course, they have access to the results of the project, but somehow these do not things that they have, let me say, intellectual property that can license them or use them. We will talk later on regarding that. because it's difference between the use or recognize it during the projects and exploitation after the project ends. There are two different steps. We will talk about this later on in the afternoon. Case 3.
Case number 3 was a Canadian case. It was about submarine maintenance, and the government required IP rights to engineering data and software for sustainment purposes. And Canadian Armed Forces can contract local firms for maintenance rather than rely on foreign companies. So what the Canadian strategy enabled was long-term cost savings and operational sovereignty. It also enabled domestic industrial benefits such as jobs and supply chains and so on. And the Canada's strategic autonomy was reinforced. So this is an important aspect when the government or the state takes control of the game in this case. And if you make good decisions, then the country as a whole and the business market can benefit. Do you have anything to add?
Yeah, it's quite known
quite
case. It's quite known case. You know, Victoria class submarine program was adopted from the UK and went from Canada to Canada. And when Canada starts to maintain and build these submarines by itself, regarding to their IP strategy, they actually decide to contract only local companies for maintenance rather than rely on the UK contractors. So this case is more on general national level strategy, to whom grant this or which company they will contract regarding operational sovereignty and also regarding their domestic industrial benefit.
Okay, and the last case is a dispute case between two partners in a project who disagreed on the ownership of jointly developed sensor fusion software. And when I speak to our colleagues, lawyers, when you prepare agreements, then you can sometimes predict what can go wrong. And based on these predictions, you can set suitable agreements or definitions, what can be used and what cannot be used. But sometimes the agreements are lacking some specifics, or some problems cannot be anticipated in advance. And this is what happened here. There was a lack of IP policy that would define who may do what and whom does. And this led to a dispute that delayed the technology's integration into the national surveillance system. So what this caused was a delay, and the state procurement program was stalled. And of course, the project reputation was harmed. And when you have such a case, if the partners appear again in future projects, then the others may be okay. Maybe we will not collaborate with them because they had a legal dispute with that partner in that program. So maybe we would like to avoid them. And this is something that is not really, working well in an environment that's really competitive and which is evolving fast. So the disputes can happen. Of course, they can happen, but this is why it is really important to have agreements drafted as best as they can be. And Aleš will talk about this in detail in the afternoon.
We have two questions, but just to add something like this, it's not problem of EDF. It's problem of the whole EU, let me say, funded programs. that the model grant agreement is somehow general and have to be specified in order to avoid situations like this. And we will talk about this later on. But now we have two questions. First is, in case 2, are there any simple legal measures to avoid the situation during the publication of the project? Yes, it's actually, we are just talking about in the grant agreement, this case or opportunity have to be specified. So the partners have agreed between them that no informations can be published before one decision on the level of the consortia will be taken that this IPR will be protected or will be probably publicly available. If they decide that this will be public available, so this will give the, let me say, research organization a right to publish it. If internal procedure within the project said that a patent should be filed or something like this, this also means that regarding the agreed internal procedures, that a research organization cannot publish before the patent is filed. So it's a question of let me say agreement between partners, but in before this problem happened. When the problem or this case 2 happened, you can do nothing regarding that on back, because the scene is done and the consequences are here.
Yeah, I just wanted to add that when something is publicly disclosed, it cannot be retracted. And even if it was published in a scientific article or in a YouTube video or whatever, when something is published, even if you remove the link or you remove the content on the website, it was still publicly available and someone was able to, print it or save it. So it was a disclosure and it cannot be retracted. So it is really important to have the patent application filed first. And of course, if there are consortia or what kind of collaborations in place, the agreements really have to be clear about this and to prevent any information from being published before the patent application or copyright is filed. So yeah, this is really something that all parties have to be knowledgeable about, and they have to keep this in mind to prevent any leaks, because leaks then lead to problems. Case 2 could be avoided if they prevented the leak, but after the leak, yeah, unfortunately, nothing could be done.
And we have another question, which is, did the Canadian government pay for those IP rights, or it was for free? Well, I do not know in details agreement between Canadian and UK government, but I can, let me say, my presumption is that they agreed regarding their rights for upgrading some specific parts or systems on the submarine by their own. As it was said before, this licensing is geographically oriented. It was territorial or geographically oriented. It is time limited as well. So they have to agree about that in before, so that the Canada get a right to upgrade some existing systems on the submarine. But as I said, I do not know in details how they specify this. Or yes, let's go further. Yes.
So in the defense industry, we can have a lot of emerging technologies, and we can have new materials, new sensors, artificial intelligence, such as AI-driven surveillance systems, autonomous weapon systems, missile guidance systems, encryption algorithms. So a wide variety of technologies and potential inventions. some of those may be critical to national security or military strategies. They need regulatory compliance or can be under national security laws and so on. So there is a lot of things that one must pay attention to, and IP management can be really complex. So this is why we are here today, of course, and to give you insights into some of the important aspects. The next slides will be dedicated to possible strategies and kind of advise what to do and how to do it. So international collaborations in the defense sector are common. To pool the resources, the expertise, and so on, it is best if there are collaborations so the knowledge can be shared. But in these partnerships, there are complex situations because we have different IP laws across the nations, across the countries. There are different backgrounds and know-hows and knowledge in the that the partners have. There may be different aspects of the invention that are being developed by each individual partner and so on. So this is why it's really important to have suitable agreements in place that all partners agree to the terms of the collaboration. Furthermore, there may be challenges in maintaining confidentiality, as we just saw in one of the cases. So we really have to pay attention and to mark the documents as confidential, just to remind constantly people who are in contact with those documents that they have to keep this secret. Of course, patent attorneys, when we receive materials, we have the professional duty to keep everything secret, and everything is considered as a business or a trade secret. But after the publication of material or the project report or artificial or an article in a journal, this becomes public knowledge. So we have to put the confidentiality first. Government agencies are important in managing the IP in the defense sector, so it's really important to keep up with the developments in this field, and knowledge of IP and key aspects are really beneficial for the preparation of strategies. So in the first part of the strategies for IP or management, there is identification of key IP. So we have to recognize and classify the objects based on their importance, the usability, commercialization, and the status. So we have to say, okay, this project will be developing this and that. And for example, we can say that we are developing new materials for bullets, and this is of major importance for some countries or some manufacturers, and therefore the usability, as there is a lot of ammunition going on, usability is high, the commercialization is also quite possible. So it is in fact needed as an invention, and it is of course desired to have it patented. Of course, in this regard, we have to consider whether this is a case of a national security or it can be publicly disclosed. So patent filings require public disclosure, as I've already mentioned. They get published after 18 months post-filing, sometimes even earlier when the applicant so desires, but this is something that I really do not suggest. It's best if we can wait. So in this regard, we have to consider whether we want it secret as a trade secret or whether we want to patent it. And when we file a patent application, we have to consider where to file it and whether the National IP Office will consider it important for the security of the state or whether it can go public. So what also has to be done is to consider that technologies evolve rapidly. So by the time a patent is granted, the technology may be obsolete or maybe different. So if this is something that is evolving quickly, then maybe it's best to keep it secret rather than to patent it, because it may be a useless patent after the time the patent would. And certain objects and innovations may be restricted. So you always, when you're identifying key IP, you have to keep that in mind. When an asset, IP asset, is identified, we of course have to identify the owner, whether this is the company, one partner of the consortium, the whole consortium, several partners or several individual inventors. This has to be tracked and identified because we have to have agreements to transfer IP rights or to have the applications filed in the correct name. So if Aleš developed something and I would be the one filing the patent application, I would have to show that I have the rights to do so. And Aleš would need to sign a document saying, okay, yes, I agree that Maya files this patent application. She should be the one owning it. And if this transfer of rights was not done, then I was not entitled to the application, and Aleš could take me to court if I was still filing the application. So this is important because sometimes there may be disputes, as you've seen in the previous case, about who owns the rights. And if you can do it in advance, then there may be objects that or obstacles that are prevented in advance.
Yes, not only dispute. We saw a few slides before. There is also different tracks on developing paths of the results of the projects. Let me say collecting some civil-oriented R&D programs and defense-oriented programs, like EDF on one side, on for example EIC transition or EIC accelerator on the civil side, or cluster 3 horizon program. And there is strictly requested that the appliers have rights to use the results of the former project. So we will talk about this later on in the afternoon, but this right to use is not only to prevent a dispute between the project partners, but also for future developing the results of the projects into the products. Okay.
Mm-hmm. Yeah, so once we have the identification of the key IP and the owners, we can then file and prosecute suitable applications, either for patent applications, design applications, and so on. We can move to and based on the desired coverage, we determine which territories are important, which are priority territories, which are maybe secondary, and ensure that this protection is extended to jurisdictions beyond the borders to cover the international collaborations and markets and so on. So this is where the Paris Convention I talked about previously comes into play. When we say, okay, we will have a patent application for a new material for bullets, we will first file it, for example, in Slovenia, and the Paris Convention gives us 12 months to file the application in other jurisdictions. The date of filing of the first application will count as the date for determining novelty, inventive step, and so on. So for determining the prior state of the art that is being used in assessment of novelty and inventive step. So we also have to decide where to file the patent application first and which territories we have to cover later on. And if there is something that is important for the national security, we have to check whether there are any secrecy agreements in place, between the country of the origin and the plant territory for IP protection. So, for example, when we file a US patent application, the USPTO usually sends us a document confirming that the application was filed, giving the application number and so on. And there is a specific box dedicated to an agreement to file the application elsewhere. So this is that you can, a statement saying you can go to other countries to patent this invention. So by doing so, the desired scope of protection can be ensured, and with these filings, we can get a number of patent applications or design applications or multiple different rights, and we have to keep track of all those applications and rights arising from them. So it is really advised to keep an IP portfolio, so to conduct regular audits to ensure that everything is identified and protected across jurisdictions. And it is really beneficial if you use legal counsels, patent attorneys, who can prosecute the applications, who can quickly update you on the status of the applications or the rights when they are granted or registered, so you can have all data readily available if something happens, if there is a legal action that you have to take, or if there is any project that you are planning to apply to, and so on. So this portfolio is an important thing also in the defense sector. It is also advised to determine the potential threats, either in terms of competitors or cyber attacks or adversaries. And we need to have clear strategies to mitigate those risks. So what will you do if a patent application does not become granted? Is there any supplementary right that we can use? Is there a copyright that we have in place? Is there a design or registration that we could use to at least partly protect the invention? How are we going to proceed if there is any competitor developing a similar device or method? So this is something that strategies come really beneficial if we know what we can do if plan A fails, and we have plan B, C, D, and so on, in case something goes wrong. So this is usually done with lawyers and patent attorneys who can say, okay, if this patent application does not get granted, or it doesn't get granted in a general way that we anticipated, we can still have a minor or a more specific patent on a specific technology that we are trying to protect.
Maybe Maya, just one question to have a feeling. How long does it take, let me say, from in average, from let me say, filing or preparing the patent file until the patent is granted and therefore it's suitable for licensing or something like this?
The timelines really depend on where you are trying to patent the invention. The European Patent Office aims to a period from 3 to 6 years. So this is what I would say is also the average time to get from the filing of the patent application to grant. Of course, there are some accelerations possible, but I have not seen any application granted in less than 2.5 years. Probably the quickest that you could do. There is theory that you could do it in less than 2 years, but I haven't seen such a case. But on average, I would say 4 or 5 years is the term that you can count on. And sometimes when there is discussion about the novelty or a particularly inventive step and the examination procedure takes longer, then you can go also longer. I've seen a patent application granted even after 20 years post-filing. It was it was a really long and extensive case handled by the EPO. And as a part of our training, when I was preparing to take the the patent attorney exam at the EPO, we were attending appeal proceedings in this case, and it was actually appeal that was taking place after the 20 years of the possible patent was lapsed. But nevertheless, the IP rights, particularly patent rights, can be used in court even for previous infringement. So even if it was something in the past, you can still take them to court even if the patent was granted after the 20-year mark. But this is something that is really not general. It's 1 in a million cases, I guess.
Extreme
It's
case,
a really extreme case. The longest I've done or I've seen in our company is 12 years. But that was, again, a specific case. There was a patent examiner at DPO who retired, and then the other examiner was in charge. But unfortunately, he passed away. And there was this third guy who came into play who knew nothing about the invention because he was completely new. And I was also taking over this case from my mother, who retired at that period. And we were 2 new people working on the patent application, and it was really hard for us. And the problem was, again, that the inventors working at the company that was the applicant of the application were no longer there. So we had no one to talk about. And what we did with the examiner, we had a phone call, a really long one, and said, okay, we will do it like this, and we then proceeded to grant. So the examiner sent me a proposal that he deemed patentable, and I said, okay, I will file it as I would have prepared it, and we then proceeded to grant, and it took 12 years from filing. So this was, again, something extreme.
Yes, we are near the time break, and yes, just to get an impression that this is not, especially in the SME companies, which they sometimes think that when they file a patent, everything is done, maybe is months or 2 months. It actually takes years before the patent is granted. Okay.
Yeah, it's a long process. It's not, it happens overnight. So just to sum up the last part of the strategy, it is also important to consider the means of commercialization. So who will use the IP rights? Will it be used by the company or also third parties? Will there be licensing agreements in place and so on? And it's also advisable to monitor and enforce every right that's being infringed. So you have to keep an eye on the competitors, not only to see whether they are infringing on your own, but to prevent you from infringing on other patents or other rights, and also to track new developments for generating new IP rights, to see where the field is going and where the competition is going. So this is something that is really a complex procedure, and it's time-consuming and really difficult. So it is best if it is done by a team of people, and that really good communication and discussion is in this group, because when you do it, as a group, you are making the best progress possible. So I guess that
yeah, we are in time. Actually, if there are any
break.
questions, probably we have one. And design can be faster. They could be part of a later patent being awarded, and you could sometimes protect at least earlier.
Yes, depends on what the design is. The designs are usually really quick to be registered. When we take, for example, EU IPO, they probably have a week or 2 to grant the design after filing. But if there is a shape of the product important, then the design would take away novelty for a later subsequent patent application. So it is still advised to file the patent application first, or at least file them both on the same day. So you file the patent application and the design on the same date. The design will be, of course, registered more quickly in a week or 2 if we are in the EU IPO system, and the patent can then take the time that it needs to get to grant. Yeah, this is something that can be used as a supplementary protection.
Okay. I hope that we answer the question. And I think now it's time for a pause. Marco?
Yes, now it's a 15-minute pause.
So we will continue quarter to 11 or
10 to
what
11.
or 10 to 11. What do you
Yeah,
suggest?
we can do it. We can do it 10 to 11.
Okay, thank you. So thank you very much for now and see you later.
Thank you.
Sì, ok.
Okay, so welcome back. Marco, do you think we can start?
Hello, Maya. This is Bruno. Yes, I believe we can start. Thank you.
Okay.
Thank you. So now in the second part of this morning session, we would like to share some important characteristics of patenting. So we first have to define what is a patent. This is an intellectual property right for protection of novel and inventive technical solutions. So this procedure is governed by various laws, national laws, regional laws, Paris Convention that I've already mentioned, the TRIPS agreement. So a lot of things have to be considered when deciding for a patent application. As I've already mentioned previously, patents last for a maximum of 20 years from the date of filing. They can only be extended for 5 years if a supplementary protection certificate is requested, and this is only available for inventions that are relating to pharmaceutical products or for herbicides or similar biocides that require a confirmation or an approval from regulatory bodies that they can be placed on the market. So this supplementary protection certificate is just an additional mark, an extension of the period for validity to compensate for the regulatory procedure that was in place for the product that is going to be So patents are the most expensive IP rights to be protected. As you've asked previously, the patent application needs quite some time to get from filing to the final grant. And even after the grant, it may still be that some procedures are in place. You will see that later on. So it's not that you have to pay once, but the costs keep coming up every now and then, depending on the procedure, on the prosecution of the patent application. So these costs also depend on the selected countries, and the more countries that you have, of course, the higher the costs are. So it's really good to plan in advance where we will file the applications for which invention and so on, to prevent any miscalculations or then abandonments of applications just because the funding is not. So patents are rights for inventions, but what is an invention? The WIPO definition says that patents protect the creations of the mind, but the invention is always a technical solution. So not just an idea, but a real solution. So it may be a novel or improved device, method, composition, for example, a compound acting as an antibiotic or anti-cancer treatment agent. It can relate to a novel composition in terms of combination of different compounds. It can also relate to an intermediate. This is more of a chemistry application. So if we have a compound, and we also can have novel intermediates or novel processes of getting or producing this compound. So the intermediates can be protected as well with patents. So the invention covers a lot of possible solutions, but it always has to be technical. But what is technical? It can be made in any field of technology. So use, so chemistry, pharmacy, but it's also electronics, physics, furniture, mechanical engineering, computer science. All kinds of technologies are there and defined in the laws relating to patenting. So a patent can protect a product, a device, a compound, a preparation, an intermediate or a pre-product, if there is something important in that aspect, so a smaller part of the final device, a process for manufacturing, synthesis, analysis, and so on, a process of preparing the intermediate or the pre-product, use of products, second medical use, which is really important in pharmacy. If we have a known compound that's, for example, used as an antibiotic, and we later discover that it also acts as an anti-cancer agent, then we can protect the second medical use as an anti-cancer medication with a patent, and it will be considered novel and inventive if there is no state-of-the-art documents disclosing that use. Also, I previously mentioned the computer programs, if they have a technical effect. So if you remember, the windshield wipers computer program was patented, but there can also be other programs. There may be, I had a case where it was a computer program or a method allowing determination of symmetry of various objects. It is also something that may come into play in the defense sector. So if we have an invention relating to recognition of some patterns or facial recognition or liveness recognition, then we may have computer programs that do so, and they can be patented. We can also protect biological entities, so organisms, if they're novel and have some technical use or effect. This can be for microorganisms that may protect plants from getting a disease evolved, so due to pathogen presence. It can also be to improved plant species, but there is a big discussion on how to formulate the law about the plant protection with patents. So there are different aspects and different ideas in the EU, in the business, and of course in the patent office aspect. So there are lots of negotiations going on, but in essence, also plant varieties can be at least partially patented. So there is really a wide variety of what can be patented, and how you can recognize an invention is that there are some certain keywords that are commonly used. So if there was an aim of the project to develop a new material, then this new is an indication that it will be an invention, so something new, something that has not been used or proposed before. Even more so if the new material has superior properties, for example, superior sealing properties, it can be more. So this is again, if something has superior properties, then it is highly likely an invention that can be patented. So the inventions can also come from different problems. I was working previously as a young researcher at the University of Ljubljana at the biotechnical faculty, and there was this collaboration with Jup, who was a manufacturer of paints, and they had a problem that the paints were degrading and they didn't know what was going on. And some of employees considered, okay, we maybe have a microbial population growing in there despite the conditions that we use and the chemicals that are present in the paint. And what happened indeed when we performed the analysis, specific microorganisms were isolated from the paint, and they were able to degrade the cellulose present in the paint. And this is why it was dissolving, or the different parts of the paint were coming apart. So we have the different sections of the paint. due to that degradation of cellulose. And what happened then in response, they developed a new, more stable paint, and the cellulose was modified in order to prevent the microorganisms from degrading it. And even more so, they also ensured further control of the environment in which the paint was packed and produced. So they are preventing any microbial infections. And this was, of course, preparing a more stable paint is also a possible invention that can be patented. If we have a building construction that needs better tracking or something that affects the gene expression or enables faster learning or something like that, something that says better, it influences, it is faster, all these keywords are indicators of an invention. So whether it will be novel and inventive, we still have to see, but nevertheless, these are the keywords that when you come up with something that is possibly patented. There are certain aspects which we already touched upon in the previous part. This is the national security concerns and the classified inventions. So the defense sector in specific can be faced with inventions that are important for national security issues. So these few next slides will discuss this topic that is regularly not really important because, or discussed because it is not something that is an everyday invention. But nevertheless, since we are in the ADF environment, we have to discuss this because it's important. So a government can make certain patent applications classified in the interest of national security. And I've only here listed 2 of the examples, but of course there are many more. The German Patent Act says that the invention can be kept secret and no publication will be made. And the competent highest federal authority is to be consulted before any order is issued. So similar is also in the Slovenian Patent Act, but the text is a bit shorter. So the invention, which is important for the defense or the security of the Republic of Slovenia, it is deemed classified and is then forwarded to the Ministry for Defense for further prosecution or further decision making.
Maybe just one question in order to clarify this point. So, who make a decision that some patent is could be treated as a secret or state secret? Who classified is this let me say task for the SME to propose this, or is this automatically done by the National Patent Office, or there are some other bodies involved in this procedure?
Okay, so the applicant has in the form for the patenting, I don't think that they have a possibility to indicate that it may be important for the national security. It is usually the National IP Office, the examiner, who determines that this may be an invention relating to the security concern, and then they forward the application and the documents to the ministry, and they have actually then decide how to proceed. The applicant, I think that they could make or raise a point when filing, but usually the IP office is the one that starts the discussion with the ministry, and then they reach a decision. To be honest, in our practice, and my mom has been working in this field where I was born, we never had such an invention, but of course this is also relating to the type of the clients that we have. What we've seen that even if there were some inventions potentially interesting for the defense sector, like there were some sensory nanoparticles or devices for use in diving that may assist divers into going deeper or faster into larger depths. They were not deemed classified or important. If there is something that maybe, a security concern, I think that it would be more related to some kind of a surveillance or facial recognition or something like that. I think that those inventions are more prone to be considered national security.
Okay.
Yeah, but nevertheless, the IP office has this right and this duty to evaluate the invention, and if an objection or a consideration comes up, then the applicant is informed, and then the whole documentation is classified, and you can only get access to the classified documents if you are getting an approval by the applicant and so on. So, yeah. This is something that may happen in inventions in the defense sector. So similar is also practiced in the United States. They have an Invention Secrecy Act that prevents disclosure of any new inventions that, in the opinion of the selected federal agencies, present an alleged threat to the economic stability and national security. So the US has a different wording, and it also uses economic stability, which is an interesting aspect, not just the security, but economic stability. What is interpreted as economic stability, I unfortunately cannot say. But again, the US has also this provision in their act. As this was a question before, I will also repeat that the US has a possibility to prevent publication of regular patent applications until grant. So this is something that not a lot of people know, and also fellow patent attorneys are not always aware of this fact. The USPTO gives this opportunity to any applicant to request non-publication of their applications, and this application is processed in a normal way, and when it comes to the notice of allowance, the applicant has the duty to decide whether he will proceed to grant and get the application or the patent granted or not. So in this strategy is used, for example, when you are uncertain whether you will receive a patent, but you don't want to disclose it to the public, and now you would just like to wait whether you will get a patent, and if you will do, then you proceed to publication, and if you don't, you just keep it as a trade secret, so nobody will know about the invention. This is something that can be used, for example, also in the national security concerning inventions, but then again, I have to emphasize that US also has this opportunity, but if you have to file in Slovenia first or in Germany first, you will not be able to file the US patent application, even with this non-publication request. So you will first have to see whether there are any bilateral agreements or so on, if you can file the US. And this possibility is also available if there are no other applications that would get to publication before the US grant. So there are certain limitations, but if the system is known, it can be quite effectively used by the applicants. So if we have a classified invention and it is processed by the National Patent Office and the Ministry, then a patent outside of that state in which it was originally filed may only be filed with government approval. This is what I've mentioned before. The United States Patent and Trademark Office gives an approval that it can be filed anywhere else. So this is something that you would need if the invention is being classified. So the prosecution of such classified applications may be possible where government agreements ensure that the secrecy of patent application will be maintained. What this means, if we have, for example, Sweden as a country in Europe, and it has a classified invention protected by a patent application that was filed, it could only be filed in further countries which Sweden had agreements, so bilateral agreements on the classified inventions. And this was something that was in place for Sweden with the United States, Great Britain, France, Germany, Italy, and Spain. So if we get to the next slide. They were not able to file a classified patent application in Slovenia because there was no bilateral agreement with Slovenia. Before joining the NATO, this was the real deal for Sweden. But afterwards, when Sweden joined the NATO has an agreement to safeguard the secrecy of inventions related to defense. And this agreement ensures that the relevant applications are classified in other NATO member states. So after joining the NATO, Swedish classified defense inventions can be patented in all member states. So for Swedish entities, actually, this became a possibility to enter research collaborations with NATO countries because they were able to protect the classified inventions. So the confidentiality related challenges are really something that has to be kept in mind because there may be some classified defense projects and they will most likely prevent any patent applications from being filed. Or there are classified inventions that will not become public. And this restricted IP sharing may result in duplicated efforts and increased costs in research and development. So what I would like to emphasize here is that when we have an invention, we first have to figure out if it's coming from a classified project and we are unable to file anything or publish anything, or whether we have the green light to publish it or file it, but we have to consider whether it's classified. And if it is, then a new strategy will have to be prepared based on the classification and the decisions from the ministry and the national patent offices. And if there are any projects, I think maybe Aleš can touch upon that, how to act when there are projects with several partners and they may be classified inventions and how to use them.
Yeah, we will have a separate section about that later on. But however, it's a very important point because there are some research done that a lot of research and development work in the EU projects is actually duplicate. And then the sources, financial sources of EU oriented into this direction can be used much more efficiently if we could somehow prevent this double researching and discovering again the things which already exist in some other project.
Yeah, so to balance patenting and security concerns, we have to predict whether the project is leading to something that is considered classified. We have to determine the participants and implement clear protocols for the exchange of information and use the agreements to define those protocols and collaborations and so on. So once developed, the invention has to be defined and considered for filing in the states that we would like to. It's also advisable to have backup plans. But now let's move to the conditions for granting a patent. So there are four main conditions in the prosecution of patent application. And if we can move to the next slide, we have novelty. And it says an invention shall be considered to be new if it doesn't form part of the state of the art. We will see in a bit what this means in practice. Then we have to have inventive step for our invention. So the inventive step is present if the invention is not obvious to the person skilled in the art. Industrial applicability means that the invention can be used in any kind of setting, in any kind of industry. So this is a condition that is really very problematic. Why this majority of applications is considered industrially applicable? I have not seen any. And the disclosure of the invention in sufficient detail. The skilled person has to be able to understand and perform the invention. So we have to consider the patent application as a protocol or as the instructions to make or use the invention. So what you need, which steps you have to take in order to have the same result.
And now if we are turning back to the trade secret, as we already mentioned, by filing the patent, you actually publish the manual how to do it, something. So you open yourself. So it's very important to take this decision whether the results will be patented or will be treated as a trade or business secret.
Exactly. So there are certain exclusions and exceptions from patenting, and these relate to discoveries, like Isaac Newton had his apple fall onto his head. He could not patent that because it was a discovery. Also scientific theories and mathematical methods, so pure calculations cannot be patented. And methods of playing games or doing business. We already mentioned the computer programs per se, so if they don't have any integration within technical features or if they don't have any technical effect. There's matter contrary to morality, but I have not seen any case on that, so I can hardly comment on what would be interpreted as matter contrary to morality. And importantly, the diagnostic procedures and process of treatment of human and animal bodies cannot be patented. This is because it is impossible to track infringements of diagnostics or treatment methods, and also they have to be free for everybody to use them. But of course, you can patent the diagnostic device or devices to be used in the treatment or compounds or preparations to treat a condition, but the process itself cannot be patented. So when you have a computer program per se, for example, and you are considering filing a patent application, maybe it is best to keep it secret, because if it's a computer program that's problematic for patenting, you will only be disclosing everything to the public, but then again, you will not receive a patent, so you will not have any right on it, except the copyright. But it's, again, questionable what you could use in a court action.
And
so,
even potential commercialization of this patent by licensing will last, as we hear, at least 3 years.
Yeah.
Maybe at that time, this solution will already be obsolete. So it's this decision or strategy, what to patent and what not, it's very important here.
Yeah, it is. So you have to, when we see an invention, we always have to consider the exclusions and the exceptions to see whether maybe trade secret or copyright or whatever may make more sense than investing into a huge patent application that will need drafting and prosecution and so on. So this deliberation is really important. To go back to the assessment of novelty and inventive step, we need to know what is the state of the art. It's also called prior art. And as you will see in the next slide, the state of the art comprises everything made available to the public by any means. So in oral description, in written description, in sold products, or in films or whatever. So this publication in any language by any means before the date of filing of the patent application forms the state of the art.
Trade fairs as well.
Yes. So we have in the state of the art patents and patent applications, designs, articles, scientific articles. This is something that the researchers at research institutes or universities are really inclined towards, and they would like to publish everything in advance. And if they publish a scientific article, it is a state of the art for a subsequent patent application. So this is an important thing to remember. Also, PhD, BSc thesis, YouTube videos, public presentations, and fairs, sold products. So this is all forming prior art. And there is only one exception to the disclosure at fairs. And this is something that is really rarely used because basically only a very limited number of fairs are recognized. And for example, the Expo is one of those fairs that you can attend first and later file a patent application. But to be able to make this fair disclosure not detrimental to the novelty and inventive step, you would need to say at the filing that you attended a fair, and you need a certificate from the fair showing what you have disclosed, who was there, where was the fair, how long it took, and so on. So you really need solid documentation to be able to take advantage of this exception when you go to fairs. But normally, fairs represent a state of the art, and if there is an intention to go to a fair, it's better to file a patent application first to prevent any unwanted disclosures before filing of the application.
Maybe at this point also it's important definition of public. What is public available? For example, we many times get the questions regarding that. What about evaluators when they see the proposals? Or what about some professional public who maybe in some closed circle were informed about some invention? In that case, this is not general public, and it's always important. We will again talk about this later on, that the attendees of this presentation have signed some kind of NDA, non-disclosure agreement, in order to keep this information close, not public available.
Yeah, exactly. So even if you have, for example, a scientific article in review process, this review process is considered non-public, and it only becomes public when it's published. But still, the reviewers may be also competitors in the field, in the scientific field. So they may get ideas from what they are reading. So sometimes it's best to wait with the submission of the article and just file the application first. Sometimes it happens that the patent applications are filed too soon before significant progress is made. So I always ask the questions whether we have any working embodiment, or whether we are sure about specific paragraphs or parameters or whatever configurations that we have in the invention, just to avoid any problems. Because if a patent application is filed and it gets published, it will also form state of the art for subsequent patent applications. And if you are in the meantime able to provide few new aspects of the invention previously disclosed, it may be detrimental for the inventive step, at least, if not for novelty. But let's go to the next slide to see what it means, a novel invention. So as I've said, an invention is considered to be new if it doesn't form part of the state of the art. And in practice, this means if there is a difference between the invention and each of the known prior art documents, there is novelty. If there is no difference, there is no novelty. In a very quick and simple example on the next slide, we have a pharmaceutical composition comprising components A, B, and C. The invention is a pharmaceutical composition comprising components A, B, and D. So what the difference is, it's clear. We have novelty because D is not C. And if we draw circles with specific compositions, we see that D is outside of the circle for the prior art document. So this presence of the component D is what makes the invention novel. In this case, we have novelty. In the second example, we have a prior art document disclosing a device comprising a sensor A and a detector B. And now the inventor comes up and says, okay, I have an invention, it's sensor A on its own. However, this sensor A is not novel because it was already disclosed as sensor A in the device. And regardless of whether it was used in a device or as a separate instrument, it is still disclosed in the prior art document, so there is no novelty. And we said that the patent can be granted for novel and inventive technical solutions, which are clearly and sufficiently disclosed and are industrially applicable. So if we have an invention that is not novel, the patent will not be granted. And there is no need to proceed to evaluation of inventive step and other conditions such as disclosure of the invention and so on, because we don't have novelty. And if there is a prior art, for example, what happened for one of our clients is that the editor of the scientific journal did not understand that the patent application was being prepared and that he has to stall the publication of the article. And then the article got published before we managed to file the patent application. And basically, this article was the same as the patent application. And of course, there was no novelty. And in this regard, we really have to pay attention to what is disclosed prior to filing and what can be considered the prior art, because if there is no novelty, then there will be no patent. If we determine that the invention is novel, so we have at least one difference between each of the prior art documents and the invention, we proceed to analyze the inventive step presence. So first of all, we need to determine which is the closest prior art document or solution, and then determine the difference between this document and the invention. The next step is to identify the technical effect of this difference. So what it does, or what is the consequence of its presence or absence, and then shape the objective technical problem. If this technical problem is not discussed in the prior art, it will usually lead to the presence of inventive step confirmed. If the technical problem is discussed in the prior art, we have to see whether this effect of this difference has been suggested by any other document that has been publicly available before the filing of the application. So if there was the same effect of this different feature proposed in any of the documents, there will be no inventive step. If the technical effect or if this different feature was not proposed or described in any other document, then inventive step is present. So to illustrate, I have a further example going back to our pharmaceutical preparation. So the prior art document 1 had ABC, the invention has ABD components, and the difference is D instead of C. A second prior art document, let's assume that this is the only prior art document that we have on file, disclosed component B. And the inventive step is present because the prior art document 2 uses a completely or discloses completely different compound E that is not the same as D. So the combination of A, B, and D has not been obvious from the combination of D1 and D2 prior art documents, and hence inventive step is present. If we have a prior art document, again, ABC, and the invention ABD, but the prior art document D2 says that instead of C, you can use D, E, F, or G. In this case, the second prior art document suggests that if you don't want to use the component C, you can use other compounds, and D is one of those suggested compounds. And therefore, if you combine the D1 with D2, you could have arrived at the claimed solution, the invention ABD, and therefore the inventive step is not present. This is the procedure that the patent examiners at patent offices usually perform. So the patent offices have different steps in analyzing the inventive step, but in essence, this is what is done and what is considered during the analysis of inventive step. Of course, there may be more complicated examples. I didn't want to complicate your life today too much, but this really exemplifies how inventive step is analyzed. And if we have a solution for which we obviously don't have prior art and that suggests it, it is wise to proceed to patent application and to see how the prosecution will go on. Is there anything to add here? No. So when an application is filed, the National Patent Office or the regional patent offices, the EPO, also assesses the industrial applicability. This is, as I said, always or almost always fulfilled. There may be a case of non-patentable inventions such as mathematical methods or laws of physics or perpetuum mobile that may be objected on the basis of industrial applicability, but these are more likely to be objected either as exceptions or exclusions from patenting or on the basis of insufficient disclosure. So this is something that is most usually okay and has a green light. But the sufficiency of disclosure is a condition that has to be fulfilled. And in this regard, for example, the EPO, the European Patent Office, says that the application shall disclose the invention in a manner sufficiently clear and complete to be carried out by a person skilled in the art. So, as Aleš previously said, you actually have to describe the manual or the how to use the invention, how to make it in full detail in order to have this condition fulfilled. If there is something missing, the examiners usually notice it and they object the sufficiency of disclosure. This is an objection that can be really hard to address because after the patent application is filed, there is no possibility to add any new information to it. And of course, if somebody says, okay, you have not disclosed this part sufficiently, you would need to add more data to it, but you are not allowed to do so. So you kind of get trapped in this situation where you need to provide more detail, but you cannot. You're not allowed to. So in practice, the description of the invention has to contain all the information necessary to carry out the invention independently without any additional experimentation or interpretation what something means. So if we have a compound saying, okay, this is the general formula and A can be this and that, and B can be R1, R2. And this is considered sufficiently disclosed if it fulfills also the technical effect that you're claiming, for example, antibiotic action. But you can keep it secret with regards to the specific embodiment. For example, R2 is used as the component B, sure that a small part is hidden from the public and the most effective embodiment of the invention may be kept secret in this manner. But even if we have a different example, for example, if we have ranges defining, okay, wavelength from 200 to 600, and we know that the best operation is at wavelengths from 400 to 450. We can disclose the widest range, possibly one narrower, but then we keep secret the best working embodiment of 400 to 450, just to have something as protected as a trade secret.
Not disclosed
Not
in
disclosed.
detail,
No.
yes.
Too many details. The best working embodiment invention. But again, this may be also problematic if there is prior art disclosing the same widest range. Then you maybe lose the possibility to patent the best working embodiment. So there has to be a consideration what would be best in this case. If there are certain aspects that can be kept secret, okay, but we have to analyze the prior art quite thoroughly to see whether it's safe to do so. But in that regard, the general description has to be sufficient to arrive at the invention and to have it working. So at least one embodiment has to be described, not just the idea. So if I say, okay, we have lights for cars and they use liquid crystals, and this liquid crystal section is controlled by a grid of electrodes, and they can emit any light pattern they would like to. So this is an invention that's not sufficiently disclosed because we are not disclosing any embodiment how to arrive at any light pattern emitted by the liquid crystal section of the car light. So in this regard, this was a real case at the EPO, and sufficiency of disclosure was problematic because there was no embodiment giving the skilled person sufficient information how to arrive at any pattern, light pattern emitted. Of course, all components and features that are new in the opinion of the inventors must be included. So we cannot say, okay, we will keep this silent, but this is the essence of the invention. So we have to provide sufficient information on that. If the concepts presented are contradicting the laws of nature, then it will also receive a sufficiency of disclosure objection, basically because this is usually a perpetuum mobile. So I do nothing and it just generates power or electricity or whatever. But these kinds of cases come in circles every now and then, but those are really rare. Is there a question on that?
Not yet.
So these are the conditions that a patent application has to fulfill. But some countries do not make this analysis that I've just described. So life of a patent without examination looks like this. We first prepare it and file it, and then the formalities are checked by the National IP Office. Formalities include checking whether the fees are paid, the applicant data are there, the inventors are named, whether there's description, the claims, the drawings, and so on, and also the consideration about the national security and other aspects that we talked previously. Some offices perform search report and provide an opinion on patentability, but if there is no examination, this report will just be an information for the applicant in order to decide how to proceed with this invention. There may be office actions and possible amendments if they are relating to formalities, but they will not be related to the contents of the claims or the application. So based on this, the application can be refused or granted together with publication, and then the maintenance fees have to be paid in order to keep the patent valid. So this is the really short process that is also used in Slovenia, for example. The Slovenian Patent Office only does the formalities check, and the patent is granted after 18 months post-filing, which means that in a year and a half, whatever you have filed, if it's not national security or it doesn't have any big formalities problems, it will proceed to grant in the form as filed.
And you mentioned these maintenance fees. We didn't talk about that yet. So when I file a patent, this is valid for 20 years and I do not have additional cost, or what is this maintenance fee?
So when the patent is granted, maintenance fees come into play every year. So if you would like to prolong the validity of the right, of the patent right, you have to pay every year the maintenance fees. So the costs do not end with the grant, but they continue with the maintenance fees, and those increase with the number of years for which the patent was granted. So for the 20th year, for example, the fees are quite high, and in the initial years, the fees are much lower. So this is a cost that has to be considered in the beginning also, that even when the patent is granted, it has to be kept valid and the fees have to be paid. So yeah, this is something that is, in my terms, called a life of a patent after grant. So some offices require maintenance fees to be paid when the application is still pending. This is the case at the European Patent Office. And also this is life of a patent with examination. And for example, this is the workflow of a European patent application. First it's prepared and filed, and again formalities are checked, and the search report and opinion on patentability is issued, and the applicant can then decide what to do and how to do it. So at this point, after receiving the search report, we are still before publication. So we can decide to prevent publication by withdrawing the patent application. So if we receive comments saying, okay, this application is not sufficiently disclosed, or this invention relates to a computer program per se that is not patentable, or relates to an exclusion. If there is a situation like this, then we can still decide to withdraw the application, prevent its publication, and have it protected with trade secret or any other right that we deem suitable for. And if we have a positive opinion on patentability and we would like to proceed with patenting, then we keep the application in force and it will proceed to publication. This will occur after 18 months post-filing, unless we ask for a faster publication, but this is not something that's regularly done. After the publication, there has to be a request for examination with possible amendments of the claims, depending on the opinion on patentability. So if claim 1 was considered not novel, but claim 2 was considered novel and inventive, we know that we have to combine claims 1 and 2 to arrive at a novel and inventive claim. So this is done in the examination phase. So we discuss with the between the applicants and the examiners in which form the patent can be granted. And there is a lot of argumentation how the inventive step is present, which documents of the prior art are relevant, and so on. So this is a phase that actually lasts for an unspecified time period. So this can last from few months to a few years or even more. So the examination phase is the one that takes time. And there may be office actions and further amendments and so on. And during this phase, maintenance fees for the application have to be paid in front of the EPO. USA doesn't have the maintenance of application, but the European Patent Office decided for this. So we have to pay every year to keep the application active or pending. So after this examination procedure is done, it may either lead to refusal if there is no inventive step or no novelty or sufficiency of disclosure, or it may lead to a grant of the patent. And then the European patent, for example, it has this specific additional steps of validation of the granted patent in selected countries, and of course maintenance of the patent in those countries that were. So this is the timeline that can extend from few years to even more than 20 in some extreme cases, but most likely, as I've said, from 3 to 6 years. Also, the European Patent Office aims to decide whether it will proceed to refusal or to grant in this time period. There are certain phase requests that can accelerate the examination. but usually the patent office aims to do it as soon as possible. But of course, the number of patent applications is increasing every year, and the burden on the examiners is getting higher. So as they're only human, they can process a limited number of applications per day or per month. So this is why certain locks are occurring. For example, Canadian patent office is really slow. They tend to need 5 to 10 years to proceed to grant, which is really long. USPTO depends on the applicant. We've seen that US applicants proceed to grant more quickly than other applicants, but it's also really case dependent. We've seen US being granted before the European patent application and vice versa. So it's really hard to estimate this in advance. But in general, if the search report and the opinion on patentability is positive in the first place, then we will be able to expect a faster grant because there will be less office actions or less prosecution during the examination. So the European Patent Convention has the whole Europe covered. Essentially, these are the states that can be covered with a European patent, and once granted, you can select all of those countries. As you can see, Bosnia and Herzegovina are currently gray. They're a member state, not a member state as a contracting member, but the European patents can be extended to Bosnia and Herzegovina. So there are a few validation states, as Morocco, Tunisia, Moldova, and Cambodia as well, Georgia, which accept granted European patents as their own national patents if the suitable fees are paid. There's a new unitary system in the EU. So the European patents can have unitary effect after 1st September 2024. And basically, everything is the same until the grant. And after the grant, you can say, okay, I would like to have the unitary effect registered for this patent, and it will be valid in 18 EU member states that are participating in this system. This is a system that's intended to maybe lower the costs, but it also has some problems because, for example, Spain is not covered, the non-EU countries are not covered, and you have to cover them separately with the old validation system that's in place. In order to have the unitary patent effect registered, we have to accept some, dangers. If we have the unitary effect and one entity is infringing on our patent, we have to file an action at the UPC, the Unified Patent Court, that was recently established together with the unitary patent. And currently this practice of the court is still evolving, and it is questionable how it will go on. Will it have more German approach to the infringement claims, or more UK, or will they develop their own practice? So there are a lot of uncertainties in this field. And also, if the sued third party would deem the patent is not validly granted, then they can file a revocation action at the Unified Patent Court. And if they succeed, the unitary patent will be revoked as a whole. So in all 18 member states of this system. So these are the dangers of the system.
I have a question. So what about the position of the UK in this system?
So when the EPC, the European Patent Convention, is not related to the EU. So the UK is still a part of the European patent, and when a patent is granted, we can select the UK normally as it was before. What happened with this unitary patent is that when the Brexit came into force, it is no longer possible to cover UK with the unitary patent. So it is mandatory to cover it with a separate validation in the UK. However, the UK has a different agreement in place. It was called the London Agreement, and there is no action for validation that needs to be filed. The patents are granted are automatically valid in the UK because the patents are granted in French, German, and English is the official language in the UK. So the patent is automatically valid in the UK, but it is still advisable to have a UK patent attorney monitoring it, to pay the fees, annual fees for maintenance, to see whether there is any kind of action going on post-grant, just to be on the safe side. But yes, the unitary patent does not cover UK because it exits the EU, but it's still covered by the European patent.
Okay.
Map showing all the dark blues are members of the UPC. The light blues will never be a part of the UPC system. So Spain and Poland actively said no to the system. We didn't want to have it, and Croatia was unable to join it because at the time it came into force, there were no there were not members. Yes, for the intermediate group. Countries, they are still considering whether they would like to use the system or not. So currently Greece is pending, but we will see what they will decide. I also wanted to discuss a bit PCT applications. These are the international PCT applications that are also commonly used. They have filing, formalities check, similar as before. Search report and publication. Again, if there is a search report that we don't like, we can still withdraw the application and prevent publication. There can be possible amendments or preliminary examination if requested, but they are not mandatory. What the PCT system offers is coverage of, basically you see the blue parts of the world that are covered with the PCT application. It gives the applicants the opportunity to decide later on, after filing, which countries they really want to cover, where they would like to patent procedure pending. And the usual deadlines are the 30 and 31 months from priority or the filing date of the PCT, if there is no priority. So if we filed the PCT application today, we would have 2.5 years to decide whether we would like to continue in Europe, in the US, in China, and so on. So this is a system that has been widely used and is really a good system to optimize the procedure in terms of coverage in the initial phase. And when you see in the 2 years with the invention where the field is going, then you can decide which countries are really priority and which are not that important. So what happens with the PCT? It is not an international or a worldwide patent. It is just a patent application, and this has to be kept in mind. It is a system that allows more time to decide on the geographical coverage, but it is no case worldwide patent, even though it receives a WO indication of the application. It's not a worldwide patent, so this really has to be kept in mind. I wanted to share some particulars of the life of the patents after grant. So we mentioned that maintenance fees have to be paid, but it is also possible that a patent receives an opposition. If a party deems that it was not validly granted, opposition can be filed and detailed explanations or evidence can be submitted to show why it was not novel or not inventive, or there were not amendments that were not allowed, or sufficiency of disclosure was not met. So these procedures prolong the procedure of obtaining a really valid right for several years, and it can end up with maintenance or partial maintenance or revocation. So a similar procedure can be also done in the court. if the opposition period has already lapsed, or if there is an infringement action and the cancellation in court is kind of a response to the infringement action. So basically, the court then decides whether the patent was granted or not. This may happen. It is in our office, it's not common, but it may happen, and it may affect any licensing agreements and further collaborations. So it has to be kept in mind that when the patent is granted, it's not the end of the story. It may be continued. I'm conscious of the time. I know that we have time for discussion.
Yeah, it's 5 minutes
Yeah.
left, and then we have an hour for possible
So
discussion. Yes.
I wanted to share some things about the patenting strategies, where to file first. It always depends on the type of the invention, the applicants, their domicile, and so on. Most of our clients use regional EP applications or international PCT applications. The Slovenian national applications are decreasing, but it may be necessary to file a national application if there is even a slight indication that it may be related to national security. But regardless of which patent application is filed first, we have 12 months to expand the coverage. As I've mentioned, the Paris Convention gives us this 12-month period from the date of filing of the first application to file elsewhere. Publication happens after 18 months from filing, unless earlier publication is requested or unless publication is prevented. So we can prevent publication if we don't like the search report, or if there are any objections, as I mentioned previously, or if something happens that we don't want the publication to happen. This can be done before the publication. We send a request to withdraw the application, and then publication is prevented. If an application is already published, we cannot retract it. So it's not possible to unpublish a published application. So we really have to pay close attention if there is any consideration about withdrawals. So the strategy should depend on several factors. So the needs and the wishes of the inventor, so the applicant. If there is a need to transfer the knowledge into real use, or building an image, or gaining points for finding, there are different strategies. So maybe if we can move on to the next. So if we can file a national application, and if it's considered classified, we will remain with it or file it in other countries where agreements are in place. We can file a national application and then a PCT application in 12 months, and then national phases of the PCT in selected countries that we would like to cover. We can also file a national application and then further national or regional patent applications in 12 months. It depends on the target territories. We can also only file EP application or start with the EP and file PCT or national applications later on. Or we can go to a direct PCT application and then go to national phases in the countries we would like to. And as I mentioned previously, the non-publication US patent application is also a possibility if there is no other national application that has to be filed due to national security considerations. We can go to the US, request non-publication, see what happens, and then before publication, if it goes to grant, we can file the applications elsewhere. This is something that I've discussed with one of our clients, but eventually they did not decide to do so. But it may be, sensible in a wide variety of options. Is also including this US non-publication record. When to choose which? Again, it depends. Sometimes if the invention may be considered classified, of course, you go to national. If there are limited funds, usually the national is first because it is the cheapest. If we need a search report, then we go either to national or the search reports such as Luxembourg or Slovenia, or we have sufficient funds and we need a search report, we can go to EP or PCT. If we need a large coverage in the first place, we go to PCT first. And if there is any prior art published by the inventors, which sometimes happens, we can take advantage of the so-called grace period. This is something that's not harmonized all over the world, but it's in place in the US and Australia, or not in Europe, so we have to pay attention. The grace period is essentially a period of 12 months in which the USPTO or the Australian Patent Office don't consider any disclosure, the public disclosures made by the applicant or the inventors themselves as detrimental to novelty and inventive step. So, for example, if there was a fair attended in the US or a sold product or a published article, the application can be filed later on in this grace period of 12 months, and the presence in the fair or the article or the sold product will not count as a disclosure relevant for novelty and inventive step. But this is really a limited thing for the US, for Australia, and some other countries, not Europe in general. So it's really problematic if we have prior art. And also later on, when the application is prosecuted, there may be further issues with the grace period and the prior art disclosures, because when you disclose something, someone else can see it, and if there is any republication or development, then that counts as prior art and can still take away novelty. So this is what I wanted to share on patenting. I have some patent infringement situations which may be interesting, but maybe first, if we have questions, we should discuss that.
So yes, now it's time for open questions. If you have someone, just please raise up a hand. Yes, Jose. As far.
Yeah,
Yes,
good morning. Yeah, good morning. Can you hear me?
Yes, we hear you.
Okay, I have a question on slide 32. Could you go there? It is focused on the first bullet point.
Yeah.
It is just out of curiosity. By the way, the first thing is to congratulate you on the presentation, which is very comprehensive and excellently delivered. I'm also waiting for the second part of the day, which promises a lot, but this part was so far so good. My question here was just out of curiosity. It is referring to the fact that, as you reflect on the slide, classified defense projects will most likely prevent any patent application from being filed. Let's suppose in an extreme case that somebody breaches your IT security systems and gets access to your information. For example, you have a new fighter jet, a whole new fighter jet, and your rival power has get access to your information systems and gets all the information, and then they manufacture the same kind of plane or using the most important technologies in your plane to make something on their own. And this question is just to separate and at the same time recognize the link between security and commercial exploitability. Let's suppose that your rival power uses that information to make a brand new fighter jet, and they sell their fighter jet based on the knowledge that you have generated to a different market. If you didn't join the protection from a security point of view with the fact that you were also protecting the knowledge from commercial exploitation, if they get access to that information, they, of course, it is illegal, but still they will use your knowledge to sell your product, and there will be no means to enforce protection on that knowledge. How would you elaborate on on such a case? Because it is not so extreme. Thank you.
Good question. Actually, it's more, let me say, I understand your question right. Thank you for your question. Of course, this is some kind of industrial espionage. So the access to the data was not granted by a company or consortium partner. There was some kind of security breach, and the competitor was, let me say, unauthorized to get this information.
But they can always say that the information they got was their own information, not. They could say that it is impossible to demonstrate that they have hacked your information systems, and you don't have additional protection by placing a patent in order to protect from commercial exploitability. I mean, there is a fact that you have lost your information. They can argue that it was generated by them and not by a process of hacking. And I think we know some suspicious cases in this regard. And they can trade with their own fighter jet, for example, and there is no additional protection by the mechanism of a patent in place.
Yes, it's the question if you can somehow prove or track this, how they get your information. So are there any tracks on the computer system? It was checked, hacked, or some other, let me say, paths, so you can prove that these competitors unauthorized access this information. So then you have some let me say tools, legal tools, in order to let me say attack him or prosecute him. On the other hand, if you know, in the case of the let me say hostage situation, and just to say some, I don't know, North Korean hackers stole the data from your computer, then you lost your data. I think that you do not have any efficient measure against them to protect your information. It's just let me say expensive lesson that you have to protect your data much more efficiently. You know, if there is let me say competitors from Europe, some neighbor country, and you have some tracks or trails that you can prove that he stole your information, then you can prosecute them by legal means. But in the case that this is one third country far away, excluded for this legal system, or even in the hostile situations, like, for example, Ukraine, Russia now, you cannot prosecute a Russian company who probably stole some information from one company and use it in their own products. Unfortunately. I don't know if I am successfully answer your question.
Yeah, thank you very much.
If I can add a bit on this, if this party that stole the information filed a patent application, for example, in Europe, then it would be possible to file an action at a court saying that they are not entitled to the invention. And if the court would decide in the favor of the original owner, so the one who had the data breach, then this application could be continued by the rightful applicant or to file a new application in its name, and the original would be abandoned. So it depends on what you can prove and what the competitor will do, or the party that has made a breach. But if you can prove, then you can take them to court. But again, it's questionable whether you can have sufficient data to support your claims.
Thank you.
Hey, thank you. I think we have another question. No, it's not a written question. If there are any other questions, please.
Well, I have another question. I'm the same as before. The European Commission has a very let's say a very important or a very wide portal for the IT help desktop. I think it is the name. They have there some. They have a platform, a digital platform where, for example, consultancy can be taken from there, or some questions can be asked to them, and there they well, they have an explanation of how the European Commission understands things related to IP and so on. My question here, and the portal is not only devoted to EDF, it is for the whole of the European Union activities, things related to the programs that are funded by the European Commission, and how they understand in general how things are interpreted in the European Commission. The question here is how is the things that they because sometimes you are not an expert and you have to dig into some particulars in this or the other project. Are they what system, international system, do they align with? Is it just domestic understanding of? Do they align with interpretation of IP law internationally? Does the scope of the things that they deal with, do you know if they in the platform are aligned with international law? Of course, I suppose it is the case, but how do you see the treatment of IP in for particular European Commission activities aligned with the rest of, for example, looking to the United Kingdom or some other third parties that can take part in projects that have a different, let's say, law system. How do they align with international law?
I think that the IPR help desk is providing advice on the basis of international law, the Paris Agreement, the TRIPS Agreement. I don't think that they're really well trained in national acts and laws valid in countries, but you can always turn to the National IP Office with questions specifically relating to their practice if there is some specific country that you would like to target. With regards to the question as a whole, with the European Commission, I can barely
Maybe in
tackle
my
that.
yeah.
Maybe Alesh knows more.
maybe like just practical experience from that. IPR help desk is a good as a first point for the questions, especially if the question is related to the EU IPR law, because there are the answer quite fast. They know the topics regarding the EU let me say field, and of course they can direct you on some other instance if they do not can provide you an right answer. So as a first point, IPR help desk is very useful, and as Maya said, it's big question how deep let me say involved in the national legislation. So in that case, a national IPR office maybe the right first point for the questions related toward national questions. And they are also, let me say, updated with all the questions related also in the relation between the national legislation and EU legislation. So for the general and EU level questions, probably IPR help desk could be the first point, but when the question is regarding the national legislation and the relation between national and EU legislation, maybe national IPR office could be the first point. What do you think?
It makes sense. It depends on the issue that you are trying to clarify.
Thank you.
But it's,
There
are not
questions.
we already solved this question.
Oh, okay.
So any more?
I have some further slides on infringement, but if we have questions.
Yes. If there is at that moment no more questions, we have a few more slides regarding the situations of infringements. We can add, and of course, if there is some additional questions in between, please just raise your hand and we can go to these questions. Are you agree, Marco, with that, Bruno?
Yes,
Yeah, sure.
Okay, thank you. Yeah, well, we have to go to the right slide now. Here we are.
So patent infringement is an authorized act of making, using, offering for sale or selling or importing for these purposes of a patented product. So if it's unauthorized, then it's highly likely an infringement if the product is the same or very similar. If the subject matter of the patent is a process, then infringement involves the act of using this process in factoring of the product, which is then sold or imported and so on. As the patents are territorial, the infringement is only possible in a country where a patent is enforced. So as I mentioned briefly in the morning, if we have a patent in Europe, it can only be infringed in Europe. So if there is no patent in the US is a free market and you can use the patent implementation there freely and without any concerns that you're infringing on this particular patent. So a typical coverage for patent applications dating back a few years is shown on the next slide. Usually Europe is covered with US, China, Japan, and then comes Canada, Russia, Australia, now emergingly also India, as I've seen from the cases in our office. Also Brazil, Chile sometimes. It depends really on the technology, but what you can count on is Europe, USA, and China. These are the countries with the most filings. Recently, due to the Russia-Ukraine situation, we've had a regulation that all applications from Russian applicants are deemed to be withdrawn for all EU countries automatically. So they are not allowing processing any applications coming from the Russian applicants. Russia did have some measures as well, but as I've seen from our cases, those are processed normally, and the patents that are valid are still valid, and the maintenance fees are still regularly paid. What also happens is that the inventors or the applicants sometimes don't know which country to choose, but then they decide based on the territory of the competitors or the most important markets for their business. So if the competitor is based in China and they don't want to engage in Chinese proceedings, they will say usually, okay, Europe is really important, or US and Europe are important, so I want to cover those countries and I don't care about China. So what they have to do is to monitor the products coming into Europe or into the US to see whether the Chinese competitors are sending any infringing products into those territories. This is quite a challenge to have it done, but usually it can be monitored well. Also, there are some customs officers that are performing searches. I've now just learned about one case that is active currently in Slovenia about custom analysis of the possible infringement by the customs at the port of Koper. So, what is an infringement? When we have a patent granted, it is granted with a certain claims. The patent claims define the scope of the protection. It may also vary from country to country. If we had European proceedings and US proceedings, the set of documents of prior art or some objections could be different, and that's why we can have different sets of claims in different countries. But to determine if a patent is infringed, we have to compare the granted claim with the product that's being placed on the market. And if all features correspond, infringement is present. So just as an example, in the next slide, there's a patent granted by the EPO. It is also granted in other countries. It's a device for divers. So an underwater scooter arranged to be installed on a scuba diving tank. And the first claim of the patent defines the necessary components for the invention to work. There's a thruster, including a motor, a propeller, a battery pack, and so on, a command joystick. And the scooter has two positions, the active and an inactive position, which are changed. And when the scooter is in the active position, the thruster is above the scuba tank and is causing motion. This is a patent that was granted in Europe, and if we had an infringing product, we would have to determine whether there's a scooter for underwater diving, if there is a thruster, a motor, a propeller, a battery pack, and every feature named in the first claim. If all features are present, infringement is here. And if there is a difference. So if there is a feature missing from in the product, then there is usually no infringement. However, even if there is a slight difference between the product and the claim as granted, it may still be an infringement. It's called an indirect infringement according to the doctrine of equivalence. If we move to the next slide, there are certain jurisdictions that have the doctrine of equivalence, and basically, even if the product does not fall within the scope of the claim, it can be nevertheless deemed equivalent, and then there is infringement. Unfortunately, there is no clear consensus on what equivalent means, and the standards differ from country to country. For example, in Germany, they have a specific test to determine whether the equivalent is present in the product or not. In France, this test is a bit different in UK as well. But France is, for example, really inclined towards doctrine of equivalence. They have a wide interpretation of what equivalent is. In contrast to Belgium, for example, where equivalence are really rarely determined or allowed. So if there is a proceeding in Belgium saying that the infringement is based on the doctrine of equivalence, the possibilities to get a successful decision are really small. In France, the courts are inclined towards the doctrine of equivalence, and certain countries like Germany, the Netherlands, and the UK are sometimes going towards it, sometimes against it. So it's really determined in advance if there is an infringement or not. Why am I explaining this? Because when you are trying to put a technology or a product into market, you have to determine also that you are not infringing on any other rights that may be active. So you have to check prior solutions, so to determine the state of the art, to see whether the invention that you have made is novel, invented, and so on. But you also have to take care that you are not infringing on other rights. And this is called the Freedom to Operate analysis, FTO. Alesh will discuss this in more detail in the afternoon. But it's really important to study the landscape of a particular technology to see what can be done and what can not be done. This is an example from court. It's actually a US case, but it is coming from the defense industry. There is this small company called Liberty Ammunition in Florida, and there was a case against the US Army. It was about lead-free copper core steel-tipped bullet technology. So the inventor, also the establishing member of the Liberty Ammunition Company, presented this idea to US Army officials, and an NDA, the non-disclosure agreement, was signed, which is a good thing. The NDA prevents the receiving party from using the received information in any form, so they cannot forward it, they cannot use it for own development, and so on. So some information was shared, but also the inventor filed a patent application, which was later granted. And the US Army was in the phase of testing and changing the ammunition program, which they wanted to develop new bullets that would be more lethal than its predecessors. And in this And what Liberty Ammunition did, of course, they filed a lawsuit, and in the case, the court decided that they are correct, and they won the 15 million judgment. And in addition, the US court also said that the US Army has to pay the company a royalty of 1. 1.4 cents for every bullet it purchases. So the patent will expire in 2027. What this means that after this date, the technology will become a part of the public sector, so everybody will be free to use it. But before this, the royalties renters or the owners of the patent. It's something that can occur, and this is why it is important to have a patent or any kind of right in place to be able to defend yourself or to receive royalties or any kind of financial compensations for the use of your invention or your solution. If in the preparation of the freedom to operate analysis, we stumble upon a patent that could be infringed, there are strategies to avoid infringement. So in the next step, we have an overview further what to do. If you don't understand the patent landscape, you can determine whether the patents are really numerous or whether they are rare patents. And if there is a particular product you're planning to do or planning to develop, are they in competition with the patent already granted or the solutions already being publicly available? So you have to identify if there are any patents. If there are, you have to somehow avoid them. And by performing these patent searches, we can discover the landscape of the technology and see which directions are possibly dead ends and which are promising and into which direction the field is evolving. So it is consistently needed to check new applications. Of course, they will be published with the 18-month period delay, but still you will have sufficient knowledge of the competition and the active patents. So in order to avoid, you can find new materials or new technologies that can arrive at the same result in a different manner. And this may also lead to new inventions. So it is always advised that when you find a patent that is active, that is valid, see how you can circumvent it, see what the R&D thinks it's realistic, or if there is no realistic circumvention of the patent, then consider a licensing agreement. So this is basically what I wanted to say about patenting. If we have
this morning session, yes.
if we have any further questions, I know that it has been quite a lot of information. You may be not familiar with patent application, their processing, but yeah, any type of question is welcome. But I hope you learned something new and that the new insights will be helpful in the future.
Yes. So if there is any more question, otherwise, yeah.
We can start a break early if there are no more questions, and then start again at 1:30.
As you said, Marco, you're a master of time, and
Well, if there are no more questions, yeah, we can start the lunch break and then we continue in 1 hour. If that's okay with everybody.
Marco, I don't know if you want, we can start at 2 also.
Okay. Yeah. Yeah. Since we have it scheduled
let's
at 2.
stick with the schedule, please. Okay.
Okay. So we make a
Thank
break
you.
now and then we continue at 2 o'clock.
Yes.
okay.
Okay, thank you.
Thank you all
Okay.
very much.
Thank you for now. See you.
Bye.
Bye. na onoj strani, ne? Pa ni. In vidim. Everyone,
Hello.
hello. Hello, Marco. You will just give us a sign when to start.
Well, people are joining in slowly. There's
Yeah.
11 of us now here. So just to be on the timetable, maybe we can start slowly and then people will drop in.
Okay. So let's start. Welcome in our afternoon session. Training together with Maya. I not need to represent us anymore. For our afternoon session, we prepared four topics, which we will go a bit deeper. First is intellectual property in international project with the focus on EDF, of course. On the second topic, we will talk about consortium agreement. And the third topic will be about strategies regarding IP protection for partners in EDF projects. And the last topic will be compliance with other EU directives, which somehow relate to the IPR and EDF. First, to go through briefly through the overview. The first part is protecting IPR within multi-part international projects. We will talk about, let me say, have a quick, brief repetition from the first part, types of IP, most relevant, so regarding patents, copyright, and design. Then we will talk about importance of identifying and registering IP on time, how to manage classified inventions and in regard to national security restrictions. We will talk about confidentiality and non-disclosure agreement between partners, about export control and dual-use implications, including the current sanctions, which are on the power now. And of course, every topic we will try to connect with some real-world practices like IPR logs, how to manage documentations regarding IP audits, etc. This will be our first part. The second part, we will focus on consortium agreement. As already said, this model consortium agreement, grant agreement, which is on disposal for the partners is general, more or less. So we have to specify it. So we will talk about some definitions and examples, what to include in this consortium agreement, like background, foreground, sideground. We will talk about access rights, where we will differ between access right for implementation, the project, and access right for exploitation after the project conclusion. We will briefly touch some licensing terms and conditions, what is exclusive, non-exclusive licensing, royalty-free, etc. And again, also how to handle third-party contractors and subcontractors within the project. On the third part, we will be oriented mostly about IPR strategy. First, how to align internal project IPR strategy with EU and national defense frameworks, how to build IPR management team within consortia. We will talk about patent landscaping and freedom to operate, about securing of IP before dissemination. We will get some hints in regard to creating internal procedures for invention disclosure. And of course, the last point after the project finished, EDF project finished, about IPR valorization, like licensing, spin-off, joint ventures, or other forms where we can capitalize results of the project. And the last part, fourth part, will be oriented toward compliance with other EU directives, of course. In the first place, EU export control regime, then the sanctions related to IPR risks, cybersecurity regulation, data protection, GDPR, and IS2, and of course, IP and defense procurement strategy. I'm sure that you probably in the place of national contact focal point will not deal directly with these questions within the project life cycle, but probably you will get some questions from the participants of the project regarding this. And I hope that these slides will use you probably just to let me say, direct them or help them to start think in the right direction in order to protect their own IPR on one side, in order also to fulfill all legal obligations which they have. So let's start with the part one, protecting IPR within multi-part international projects. Objectives of this part are we should understand how IPR is created and how IPR flows within the EDF collaborative projects. We would like to identify critical risk in joint R&D settings and to provide practical methods for tracking and managing emerging intellectual property. On the morning session, Maya gave us a perfect presentation regarding IP and protections and main types and forms of IP. Here is just our brief overlook that as industrial intellectual properties as patent and design are important regarding to defense project as well as copyright. And we said patent protect technical inventions like new missile guidance systems, radar sensors, etc. Duration is for 20 years. Copyright protects expression of ideas, not ideas, but expression of ideas. And these are, for example, source code for AI models, training manuals, etc. And its duration is the life of author plus 70 years of the date of his death. It sounds quite a lot time, but there are examples which can show you that this 70 years is, let me say, just the right time. Design is oriented towards product appearance, and it's regarding to interface of military applications, housing, drone housing or vehicle housing design. And its duration is 5 years primarily, but it could be extended up to 25 years. So these three types are, let me say, the most common in the defense sector. Why this is relevant to defense? Because it protects technological innovations like weapon systems, sensors, software, unmanned systems, advanced materials. And this allows the owner to exclude others from making, using, or selling the invention for limited time, as we said, up to 20 years. In this form, as patent, is particularly important for, let me say, heavy outputs in EDF projects, like a new propulsion system, some encryption mechanisms, navigation of autonomous vehicle, etc. But when regarding to the patents, we already mentioned that we have to take care about special consideration because they exist security-related patent restrictions. Because many countries, or almost all European countries, reserve the right to classify patent application of national security purposes. An example, this is Article 17 in Slovenian IPR Act. And these classified inventions often cannot be patented abroad unless explicit governmental permission is obtained. So without governmental permission, you cannot patent your results out of your country. Because this government use clause allows states to use the invention without infringing private rights, especially under emergency or national defense needs. So in the case of emergency, government have a right to use discoveries directly without the patent filing, patent protection, etc., but immediately. As we heard before, that this patent application can last up to 20 years or typically 3 to 6 years. Government use clause allows states to use it immediately. Yes. We already said that we have to take care about of IPR not to disclose it to other parts before the patent is filing. So, timely identification and registration of intellectual property is actually essential for get strong protection for your innovation, to avoid disputes, and of course to ensure the inventor exploitation rights. This is especially important in international projects where we have consortia consist from partners from different countries which co-develop new technology. So we have in these collaborative projects declare or identify all knowledge. Very important task, actually. It's strategically critical. We see some cases before when we get a dispute because of this identification and clarification of ownership leads to the problems within the consortia. Why is this important? Because on the beginning, we want to have clarity on ownership and use. And without this identification, it's very hard to prove who owns which IP asset. And this clarity on ownership actually helps to define which partner has the right to use, has the right to license, or has the right to commercialize results. Risk mitigation helps to prevent us unintentional misuse of third-party IP, including within the consortia, and of course reduce risk of IP leakage or unauthorized disclosure. And why is important from the legal and regulatory compliance? Actually, model grant agreement within the EDF project requires clear documentation of IP, which is used and generated within the project. And of course, as the consortia, we are responsible to be in compliance with, let me say, EU dual use or export control laws. And we don't want to break this legislation. And of course, allocation of access right depends on clearly identified IP categories. As I mentioned before, It's happened now that you can, as a partner with an EDF project, in example, you can continue development of your product within some other EU-funded R&D project. But in order to have a right to do this, you have to have access rights to the results of the project. And if this is not clearly identified in the former project, it's practically impossible to get this later on. I can tell you it's a practical case. It's happened to me. It's one instrument, R&D instruments called EIC Transition for TRL 3 to 6 in EU, which strictly requests access right for the former finished project. Researchers want to apply for such a project, and I personally check 650 projects of the university, former projects, concluded project, and no one have access rights so to be eligible for EIC transition. It was impossible to help them to apply for this scope. So it's not let me say simple understandable that everyone will assure its access right. No, it's mostly become somewhere in the clouds, in the gray zone. It's not identified, and later on, it's very hard to get any access right after the project is finished. So, in the EDF project context, we have three types of knowledge, which is, let me say, which live in the project. Background, foreground, and sideground. Background knowledge is knowledge which every partner already possessed before the project started. So the partner brought this background into the project and developed it prior to the action. For example, company have existing simulation software and some patents claimed before the project. So this background can now be granted to other partners, with or without royalties, upon the, let me say, negotiation, but must be listed. Must be listed. So conditions for use this background of some partner have to be listed. Foreground, as a second form of knowledge, are actually results which are generated during the project implementation, including intellectual property rights. For example, new algorithms developed, some test prototypes, patentable inventions. Who is owner of this foreground established in the multi-partner, multinational project? Actually, usually owned by the partner generating them, unless joint ownership is agreed. Joint ownership means that all the partners have to discuss and negotiate about the share of the patent which is filed during the project. And the third form of knowledge is sideground. This knowledge, this intellectual property, is again generated during the project, but not within its scope. So this is not a result of the project, but this is one knowledge like research outcome developed using own funding alongside the project. And this side ground is not automatically available to others. And again, side ground have to be clarified before in order to avoid all disputes later on. When we are looking on the EDF specific consideration, we know that a model grant agreement actually required inclusion of a background IP lists, description of ownership structure for all foreground results, and clear definition of access rights for both implementation and exploitation period. So we have to differ implementation period when the IPR is used in order to finish project obligation. So during the project, and exploitation, which is actually commercial exploitation after project finished. So these access rights have to be clear defined. As we said many times today, there is no retroactive addition. So knowledge not declared as background cannot be claimed later, which actually could have very sharp consequences for the partners if they do not declare it on time, because it's limit their ability to control use of their own pre-existing knowledge. And of course, proper IP classification support compliance with dual use and military technology export regimes. Case. For example, we have one Slovenian SME with a joint consortia with the German defense contractor. The SME brings its own combusting optimization software, which means background, contributes to the new artificial intelligence module as a foreground. But on the side, the SME develops a testing protocol, but during the duration of the project, which is a side ground. Oh, here we have some points to stress out. If the combustion software is not listed as a background, partners may wrongly assume that they can freely use it. Second, the AA module IP must be co-owned. So it's co-owned with the German contractor and Slovenian SMEs, and probably some other partners within the project which somehow contribute in the development of this IA model. And the testing protocol should be declared as a side ground. So other partners cannot claim any rights regarding this side ground. Managing classified inventions and national security restrictions. In foreign finding restrictions. For example, we said that case in Slovenian IP law article 17, and European countries have its own national equivalents. So, in defense-related R&D projects, also those funded under the EDF, some inventions may be classified for national security reasons. And in that case, classification impose limitations on how these inventions can be disclosed, patent, licensed, transferred, especially across border, outside of some national countries. And it's important because why? Because failure to comply this can lead to legal violations, loss of use rights, or national security breaches. So what is actually classified invention? Classified invention is one whose disclosure may pose a risk to national defense. What can include this? This can include military use of materials or designs, AI algorithms for tactical decision makers, sensors, cryptographic methods. And such inventions are always subject to screening and restrictions by national authorities before any form of public disclosure or IP registration outside the country. As we said, it's actually a duty of National Patent Office or their right and duty to take care regarding that and to inform Ministry of Defense or other bodies regarding the classified inventions, and then start negotiation or a process. What is classified and which are the conditions for use, patenting, or selling outside of the country. Legal basis is in national IP law, as we said, Slovenian IP law, Article 7. We have if an invention is deemed to affect national defense, it may be declared classified by the Ministry of Defense. In such a case, no foreign patent application may be filed without prior approval. Filing abroad is only possible with the bilateral agreement, which of course have consist target country and ensuring secrecy. And the breach of this provision may result in criminal liability. Different countries have its own parallels, like Germany have Patentgesetz Section 5. France have articles in their Code de la Propriété Intellectuelle. Italy, Poland, others have comparable secrecy orders. So similar legislation exists in almost all EU countries. But interesting, on EU level, there is no unified classification system currently. So classification and secrecy are still national competencies, even within EDF projects. So, which are the main points or key restrictions we should be aware of? First is foreign filing restriction. So, no foreign patent application allowed without security clearance, secrecy obligation, disclosure, including within the consortia, limited to authorized persons, export control. Export may fail under dual use or military technology control list. And as said many times, no automatic publication. Patents subject to deferred publication or redaction. So, in relation to EDF projects, it's obligation of each partner to assess whether its results fall under national defense related classification rules. And consortium agreement should set the rules or policies, internal IP policies, which should address how to report mechanisms for sensitive results, obligation to notify national authorities, secure communication protocols. And in some cases, only domestic patenting may be possible, because international protection will be limited or prohibited. What are best practices for managing these classified or potential classified inventions? First point is always early screening. Early screening. Do this on time, before the problem begins. Appoint internal or external advisors to review all potential sensitive inventions before public disclosure or patent filings. Second, consult national authorities. So engage MOD or National IPR Office immediately when some suspicious invention arises and there is a possibility that invention may be classified. Third, implement access control. We have questioned before what's happened if someone get this information. Limit access to all technical data to pre-authorized personnel. So we all know, need to know it's the right statement. Access to technical data or the documentation is granted only to the persons who need to know some details for their work. So it's good to use document classification labels like restricted, confidential, secrets where applicable. This is not a national classification list. This is internal classification within the projects in order to aware all people, researchers, workers, etc., to take care about the security of the information. Avoid public disclosure. So, classified inventions should not be present on conferences, papers, or marketing documents unless it's clear whether they can be presented or no. Training, especially for researchers. As I said before, because the researchers work on this, statement, publish or perish. They have to publish everything. So train them. Ensure engineers, scientists, project management understand why this is important and how to implicate this classification and how to report this obligation. And of course, export compliance alignment and coordinate classification process with export control checks, especially for dual use items. Case. Estonian SME developed a novel control algorithm for drone coordination within an EDF project. Upon internal review, it is determined that this could be used for autonomous strike systems. Invention is flagged, and the request for classification and review is submitted to the Ministry of Defense. The invention is classified, so the company has to do what? File only a national patent application, if it's permitted from the side of MOD. Refrain from filing any foreign applications. Mark all internal documentation as confidential, and also limit dissemination even within the consortium. So only partners who need this to achieve the project goals have rights to access these informations and data. Well, as we see that the classified documents are quite strict even within the consortia. So here we will talk about confidentiality and NDAs between the partners. So how to protect sensitive technical and commercial information in EDF projects. Yes, you know that EDF projects consist from different partners, from different countries, from different legislation system, different jurisdiction. So confidentiality is essential to prevent this misuse, loss, or leakage of sensitive information. Especially all IPR technical data security relevant knowledge, pre-commercial strategies. And non-disclosure agreements and robust confidentiality clauses within the consortium agreement present actually this legal backbone for this protection. So strong consortium agreement and strong non-disclosure agreement are prerequisite for the confidentiality between partners. Why is this so important in defense collaboration? Well, first of all, we should somehow protect competitive advantage of the partners, SMEs or researchers, R&D providers. Actually, often share this know-how and trade secret during technical meetings and discussions. We have consortium meeting, and of course, this data, technical data, or some know-how is shared between the partners. But we have to know that this leakage could compromise future patent filings, commercial deals. That's why this NDA is very important, not to lose the novelty of the future patents. Because these early disclosure conventions actually may disqualify future patents, because we lose the status of novelty. This is one point. Second point is here that disclosure could also lead to ownership disputes if contributions are not properly tracked. As we mentioned before, it was dispute between R&D organization and the company who both claim the ownership of their result within the project. And last but not least, some technical data may fall under dual use or military export control, which requires access limitation, with, of course, legal consequences as for individuals as for organizations. So, briefly, what is NDA, non-disclosure agreement? Actually, NDA should consist at least these 5 points. Definition of confidential information. So we need clear description regarding which technical data, which source code, which algorithms, which design, etc. are part of this NDA. What are obligations of receiving part to protect, not disclose, only used for permitted purposes, not for everything. Exceptions have to be stated, probably some informations which are already public, lawfully received or independently developed. Term of confidentiality. This in general often lasts 3 to 10 years, maybe longer for some defense-related content. And finally, consequences of breach. So this NDA should include liability, damages, potential exclusion from the project. NDA is actually legal contract used to protect confidential information between parties and also between partners in the project. Not only in the partners, also with the subcontractors, which we'll hear later on. Well, not only NDA, consortium agreement is actually, how to say, Bible of every EDF project. Consortium agreement defines the rule of the game. And in the part, where these confidential provisions are stated, these topics should typically cover scope of confidential obligation. So what have to be kept secret? Handling of oral and written disclosures, duration of obligation. This duration of obligations usually lasts even after the end of the project. Access right versus confidentiality. We have to balancing legal access because partners need information in order to run project activities, to get project results, to finish the project. And we have to balance between this right to know or need to know with security needs. And of course, strictly marking and labeling of confidential informations and obligation in subcontracting. So we have to ensure that third parties like subcontractors are also obliged to treat the informations with right level of confidentiality. Some practical measures, like within the project, we should establish some kind of marking protocols by using of standard labels, confidential EDF project or internal use only, etc. And all partners should adopt a unified classification scheme. It's important, you know, in EDF, we have projects also with 30 partners. And if some partner use their own classification scheme, this could establish misunderstandings. So all partners should adopt unified classification scheme. Access to the technical data should be based on this need-to-know principle. So access is limited only to the persons who need this information for their work, not for the curiosity or something like this. Use secure storage systems like encrypt cloud, control servers. It's good maybe even if you're not working within the classified document to internally implement some ISO 27001 standard about cybersecurity, information security, which should set very strong and robust standards for data security. Training, informing, and awareness for the people working in the project. We should educate technical teams, managers, all the persons involved in the projects on what is considered confidential and refresh this from time to time. Include confidential training in onboarding. Even we have this grant agreement, use of standalone NDAs for pre-consortium discussion or bilateral exchanges outside the consortium agreement. Standalone NDAs is a very useful instrument. It should be signed in order to enforce confidentiality. And last but not least, document retention and disposal policies. So define how long these confidential materials are kept and how they are securely destroyed. Example. During the testing design phase, Italian partner shares a detailed blueprint for an advanced radar antenna systems. Although not patented yet, this design is considered sensitive. So, all partners are bound by the consortium agreement to keep this data confidential for 10 years, with use limited strictly to to the agreed project scope. The shared file is marked EDF project confidential, stored on an encrypted server, and only accessible to authorized team members. So this is the case how such information should be used, how should be marked, and how should be stored. Legal frameworks which we have to consider when we are implementing these measures on the EU level is, of course, Trade Secret Directive, which protects confidential business information against unlawful acquisition and disclosure. The different national laws, which often reinforce obligation under NDAs and consortia agreement in case of breach, like civil penalties or even criminal prosecution. And of course, EDF model grant agreement, which impose dissemination restrictions and obligations, how to protect sensitive results. Export control and US use implications, including the current no export to Russia clause. This export control and dual use regulation is really important in EDF projects. Why? Because these rules actually govern transfer, dissemination, use of sensitive technologies on the both sides, within EU and outside of the EU. And this have direct implication for how IPR is handled, how IPR is shared, and how it could be commercialized. What is actually this export control? Export control actually means legal restrictions on the movement of goods, software, technologies, intellectual property rights across border for the reason of national security. And this export control applies actually to the physical export, like hardware prototypes. Intangible transfers, like emails, cloud uploads, knowledge sharing. Technology transfers, including IP licensing, joint ventures, and remote collaboration. For example, there was a case from the last week, I think, or 2 weeks ago. It was regarding the sanctions to China, which wants to prevent them to use artificial intelligence for learning their AI solutions, or on the way that they prevent them to transfer this data via internet. So the roundabout was that the Chinese rent hypercomputer in Malaysia and bring on the physical hard disk all necessary data, some terabytes of data, to Malaysia, optimize their AI code there, and get it back to the China. So it was the case how to avoid this transfer, intangible transfer, because it could be tracked if they will send it via internet. So this export control, why I mentioned this, it's not only that apply to physical export, like machines, tanks, or I don't know, drone or something, or prototypes, but it's actually affect also these intangible transfers, which is actually software, which is more and more important. What are dual-use items? So these are technology software components which could be used for civilian or military applications. And there are examples, these 6 examples here, like high-performance sensors, advanced material encryption software, systems for pattern recognition, drones, high-frequency antennas. These are regulated dual-use regulation. Of course, in this dual-use regulation, importance are annexes, Annex 1 and Annex 4, which much more in details describe which technologies and which components consist in this directive. So first level is EU dual-use regulation. Second level is national export control laws. So different countries like Germany, France, Slovenia, Croatian, Italian, whatever. In general, if you summarize this, legal frameworks is on different level. On the top is EU regulation, dual-use directive, which controls export, transit, brokering, transfer of dual use. Second level is national law, which means national implementation of export control obligations. And third level is, of course, EDF grant agreement, which actually requires to all partners, beneficiaries, to comply with all applicable laws, including export restriction on EU or national level. In addition to this dual-use directive, we have since 2020 this EU export restriction, which prohibits export of sensitive goods, software, and technology to Russia. For the implementation for EDF projects, this means no licensing or foregrounding IP or software that may indirectly transfer results to Russia. IP exploitation plans have to be reviewed. So exploitation plans have to be in compliance with sanction regimes. And regarding to partners, project partners, subcontractors, and final users, like defense integrators. So this no export to Russia involve all partners, subcontractors as users. Any violations means breach of EU law, means project termination and financing, means criminal penalties, and of course, it means big damage to national or consortial reputation. So, as we see, we have some clash between or intersection between export control and IP. So in the situation that one company in the EDF project wants to license patent technology to non-EU company, it can happen that this may require export authorization. In the situation that we want to upload source code to cloud service hosted in the US, or we actually do not know where, may constitute a deemed export. Joint development with non-EU subcontractor. In this case, we have to assess whether this dual-use tech is being transferred. And of course, public presentation or publication of project results means actually risk of unauthorized disclosure of controlled technology. What are best practice to be in compliance in EDF projects? First is to classify technology early. It's good point, especially in the big consortia, to appoint an export control officer or even team which is responsible for monitoring and ensuring compliance. To include export control clauses in the consortia agreement. Always check third country partnership. And to keep records of export license applications, screening procedures, and internal training, maintain internal documentation. In the case something happened, this tracking record will actually help to solve the problem. Example. Croatian Defense SME developed sensor model for guided munitions in an EDF project. And now they plan to license the design to a manufacturer in Turkey. First, after the review, the sensor is found on the EU dual-use list. That means that a license is required, and the licensing process has to assess risk of re-export to restricted countries, including Russia. And due to risk of indirect exposure, the deal is paused, and the partner, Turkey company in that case, have to submit end-use certificate. So, what every EDF participants have to do: screen all results for dual-use classification, identify national export control use, check licensing requirements for IP exploitation outside EU, include export control in consortium agreement and in internal IP strategy, and of course stay up to date with EU sanctions and embargoes. As we know, that these sanctions packets are changing, and content is changing almost sometimes on the monthly level or quarterly for sure. So we have to be all the time up to date with the current sanctions which are in force. What is best practice for dealing, for managing the IP? That effective management is not relies on legal definitions, but the practice which is implemented during the project. So to ensure how the IP is tracked, controlled, to have all documentation from start to finish. Because, as I said, EDF projects could be very large, huge projects with a lot of partners, with a lot of cross-border defense collaboration, and where the IP ownership is sensitive, have high value, is confidentially, and of course, partners should assure them exploitation rights after the project is finished. What is an IPR lock? Actually, this is IPR document, continuously updated document, where all IP assets generated and used in the projects are listed. So 5 key features: identify the type of intellectual property, whether this is patent, software, design, trade secret, etc. Records the owner and possible co-owners of this intellectual property, links this intellectual property to the project tasks or work packages within the project, filing dates, publications, protection status, track all the time, and of course add any notes and any restrictions like classified, dual use, export control, etc. This IPR lock will leave document during the project implementation, but it helps partner a lot to avoid disputes, to comply with grant obligations, to protect innovation value during and after the project. So this shared documentation system, which have to be secure, structured, and accessible only to authorized person, should have these 5 components like background IP register, foreground IP tracker, invention disclosure, patent filing summary, and access rights logs. So why explained on the right side? It helps a lot. It helps a lot because in 3 years, multi-partner projects can easily came to misunderstanding or losing something, to confuse some partners. And this centralized IP documentation is from the focus of intellectual property rights, very useful document within the project. Well, what about IP audit? IP audit actually is a tool which helps to review how IPR is created, how it's protected, how it is used, how it is disclosed through the project. It's good to have these IP audits at the start of the project in order to establish IPR baseline and also to verify, claim the background of the parties. In the midterm review, actually, we can assess IP management effectiveness, to update logs, and also to resolve some possible open questions before deliverables and disseminations, ensure that all foreground is appropriately protected before results are published. And at the project close, it's a final review, which ensure that all IP is properly documented, assigned, and that exploitation plans are in place. Who can do this audit? We could have internal IP manager in the small project. We have legal IP term in the bigger project, or we can use some technology transfer office. And of course, consortia could involve some external auditor, which is recommended where they have very complex IPR portfolios. Maybe Maya, you should add something.
No, but I wanted to ask you, what happens if you have a consortium agreement and the partners maybe change, or the partners has one of those has a spin-off or spin-out, and the landscape kind of changes in terms of partnership? Does it get extended to the newly formed spin-out, or will you get that?
We will in the next part, in valorization of the, yeah.
Okay, I was thinking about it because this is a realistic scenario but yeah, I think that it's really the take-home message here is that it is really best to keep track of everything that's being done and what will be done, and to be careful with whom the information is shared. I think this is the most important message that has to be kept in.
Okay. Benefits of these practices, of course, risk mitigation to avoid disputes, grant compliance to satisfy obligation under EDF, exploitation readiness to ensure that IPR is met and ready for post-product use, and strategic clarity, which help partners to track innovation trajectories and to prepare future proposals. Here are practical implementation steps. Assign responsibility, create IPR reporting templates, define procedures in consortium agreement or IP policy as separate documents, probably in the project. set up a central IP registry, involve all stakeholders, and link to exploitation plan. Example. In 3 years, EDF project consortia, which is led by French integrator, tracks all IP using a centralized Confluence page. Each work package leader submits quarterly IP updates. Foreground results are documented using standardized documents. Before submitting deliverables to the Commission, an internal IP audit is conducted to verify that no confidential or unprotected IP is inadvertently disclosed. And the final IP logs become the foundation for commercial licensing and spin-offs after the finishing of the project. Some useful sources if someone wants to read more. And we are on the part 2. Is there any question regarding this first part? We can deal it now or in the end. We have about 180 slides to finish. So it's up to you if you have some questions or we can just continue.
Just check. No, we don't have any questions in the chat.
Okay, thank you. So let's continue. We are on the part 2. Here we will talk about the consortium agreement. Objective of this part is to clarify legal and strategic importance of the consortium agreement and explain how consortium agreement ensures IPR ownership. We will start with some definition and examples. We already mentioned background, foreground, and sunground. We will talk about access rights, licensing terms and conditions, and how to handle third-party contractors and subcontractors. As we already said, in European and EDF projects, ownership and usage rights of intellectual properties must be clearly categorized. And the standard framework distinguishes three main types of IP contribution. We already mentioned background, foreground, and sideground. Background, we said, is existing knowledge which exists prior to the start of the projects. So it's developed before the projects or independently for the project, can include existing patents, existing software, trade secrets, designs, tools, etc., but must be explicitly declared in writing, probably in annex to the consortium agreement. And this background may be subject to access right, but it's not automatically granted. Example, Slovenian SME enters the project with a patented heat exchanger design developed in 21. This is clearly a background IP. University partner brings an AI software models created in earlier Horizon 2020 project. Again, background. What is risk? If not declared upfront, this background IP may not be accessible to partners or may lose protection if unintentionally disclosed from some partners or by owner. Foreground, we said that this means tangible and intangible outputs which is generated during the project. So it's created by or under the project using the project resources, automatically owned by the partners who generate the result, and can be individually or jointly owned depending on contribution. And of course, this foreground is subject to rules under the EDF grant agreement. So we have to state ownership, protection, access rights, and exploitation obligations. in advance. Examples: novel cryptographic algorithm developed jointly by two partners. This is jointly owned foreground. Test results from a wind tunnel developing during the projects. Foreground data. Prototype of dual-use sensor system developed under work package. It's actually tangible foreground asset. And this foreground must be tracked, protected, and exploited according to the grant rules. As we said, all the beneficiaries must report all the protectable results promptly. Sideground. This background is actually simple understanding, also foreground, but sideground, as we said, it's some knowledge which is developed during the project, but outside the funded project scope, outside the planned result of the project. It's not planned within the project objectives, but it, let me say, just it is created. Usually this sideground is developed independently by a project partner, which use for this their own resources, and it's not automatically accessible to other partners. It's how some partner doing something and can become commercial or strategically relevant, especially if it's similar or is somehow overlapping with other result of the project, with foreground results. Example: partner develops machine learning model using internal R&D while working on the EDF project, but not under any project task. Improves its internal cybersecurity tools during the project period as a side effect of its EDF-related activities. These are two examples of sideground. Of course, we have to deal with some risk. This could lead to disputes if there is unclear whether a result is foreground or sideground. So should be identified very early and also exclude from access rights unless separately negotiated between partners. A short summary table regarding backgrounds created before the project starts, no link to the project tasks owned by declaring partners, is accessible to others, yes, if agreed in consortium agreement. Foreground is created during the project, it's linked to the project tasks owned by the partner or partners which generate it. It's accessible to others under access rules. And sideground is again created during the project. It's not linked to the project tasks. It's owned by a partner who developed it, and it's not accessible to others unless it's licenses or agreed on some other ways regarding the terms of use. Practical tip. To the consortium agreement, is very good to include annex, which lists background IP, joint ownership principles for foreground, and exclusion cases for sideground.
I maybe just want to add here that when drafting the annex to the consortium agreement, the partners, or at least one partner that I collaborated with, had an issue with the background IP. It was a running discussion what really to include in the background. And in the end, we decided that they should add everything that was relevant for that project as background, in order to prevent any miss-outs or any left-out technologies that were really forming the background of the partner. So maybe, Aleš, if you have any further tips, but I in that case, I advise that they should include everything in the background just to be clear and to be on the safe side, to state everything that they had developed before the project.
Okay, we are talking about access rights. What is here important is that we have to differ between the implementation access right, project implementation, and future exploitation access rights. Because in EDF projects, multi-partner projects, all participants need to use intellectual properties of other partners in different phases. During the projects, this means implementations, and also after the projects, when they want to exploit the result of the project. To enable this, we have to grant these access rights and conditions on which these access rights are granted. In order to avoid misuse of intellectual property, to clarify partners' obligation, and of course to ensure smooth project delivery and post-project commercialization, valorization. What access rights? This is actually legal rights which are granted to another consortium member to use a specific piece of intellectual property, whether in background or foreground, without acquiring ownership. It is limited in purpose, so we have to differ between implementation during the project and exploitation after the project. It is non-transferable to third parties unless otherwise agreed. And of course, it is subject to conditions for use this intellectual property. Is this royalty-free, fair, and reasonable terms of use this intellectual property? For the implementation, actually, this access rights allows partners to perform their project tasks. It's actually granted automatically upon request. It's applying to both background and foreground, if needed to carry out specific tasks, and have to be royalty-free, and that's agreed otherwise. Example, partner develops software during the project. Another partner responsible for testing needs access to that software to complete their assigned work package. Access must be granted free of charge if needed to implementation. Limitation is that it's valid only during the project duration and only for non-commercial use. So only for project-related work. But access rights for exploitation actually allow partners to use results to exploit project outcomes after the project ends. Again, can cover foreground and background, but it's not automatic. Have to be requested, have to be negotiated, and can be subject to royalties or some fair or reasonable compensation, depending on negotiation and agreement. And these terms are often set in consortium agreement. Example, when the EDF project ends, partner wish to commercialize new UAV component, however, to rely on data processing algorithm developed by another partner. The exploiting partners have to request access and negotiate licensing terms. So, these access rights are not granted unless explicitly requested, and of course can be granted, but can be also refused if no access clause exists, or if purpose falls outside exploitation scope. Summary table. I would not stop here, it's just have an overview of what is already done for fast checking. And the best practice here for managing access rights is, again, clearly defined background IP. As Maya said a few moments before, include all background which somehow related to the project scope. Use standard clauses or similar templates of Asdeska tailored for defense projects. Set time limits like 5 years, 10 years after project dates. Record all access requests and approvals in this shared repository. Avoid ambiguity. So we always have to define what constitutes fair and reasonable use or fair and reasonable compensation, especially for SMEs, because many problems in the projects became when especially SMEs use the terms which are, let me say, often used, but there is no clear definition of what this means. And for the basic, these definitions are like, what is the project? We could have 10 different opinions what the project is, but we all knows what is it. What is fair and reasonable compensation? Wow. And of course, the last include fallback clauses in the consortium agreement, like mediation in case of denial. Things like that. Example. German defense integrator used Slovenian SME patented control unit in their prototype funded by EDF. During implementation, this access is automatic and free for testing and integration. After the project, German company seeks to market the solution, so they have to request exploitation rights, which the SME may grant under commercial license agreement. So a separate agreement, which actually define the terms for the commercial use. Licensing terms and conditions. We are talking about different forms of licensing, like non-exclusive, royalty free, fair, reasonable, etc. Licensing actually governs how partners can use intellectual property, which is developed into the project without transferring ownership. And selecting the right licensing model and clearly defining its conditions is very important if we want to protect innovations in the exploitation and collaboration. What is a license? A license actually is a legal agreement in which the owner of IP, licensors, grants specific usage right to another party, which is licensee, under agreed conditions. These conditions are: who can use the intellectual property, for what purpose, for how long, under what costs or restrictions, in which territory this license is valid. These conditions have to be agreed by the both parts, of course, and may apply to background, to foreground, and to sideground. Common licensing types, here are these 5 types. We have non-exclusive. So licensor can grant the same rights to different or to multiple licenses. For example, software code is shared with all partners within the project. Exclusive means that only one licensee has rights. Even the licensors may not use it. So it's actually transferred the ownership to a licensee. Partner licenses a rather algorithm exclusive to a defense integrator. Sole licensing, different is that the licensor retain rights, but only grant one licensee similar right. Example, SME grants exclusive marketing rights in one country. Royalty-free means that no monetary compensation is required. So partner grants use of testing interface software at no cost. Fair and reasonable means that that use is allowed under mutually agreed market at aligned terms. So it's very good to, as we already said, to define what fair and reasonable use means. Example is like licensing background antenna IP for post-project commercialization. In the EDF context, the licensing principles are like this. Under the grant agreement, access rights for implementations are typically royalty-free. Access rights for exploitations are actually granted on fair and reasonable terms. There is no automatic transfer of ownership with licensing, only defined usage rights. For access to background IP, licensing terms, especially if not royalty-free, must be declared in advance, typically in the background annex of consortium agreement. Which are elements of licensing agreement? Typically element these 8 points here. Scope of use. So what the license is allowed to do. Territory limitations. Durations. Exclusivity, is the license exclusive or non-exclusive or sold. Compensations, what is a royalty rate, lump sum, royalty-free. Field of use, we can, or a licensor can restrict to use if results in some specific applications like naval systems or civil aviation, something like this. Termination conditions, so breach clauses, expiration or project ends, and of course sub-licensing, whether licensee can pass rights to another party. So these 8 elements are, let me say, core of every licensing agreement. Here we have some examples, scenarios, like French SMEs provide pre-existing diagnostic software as background IP. All partners use it during the EDF project. License is non-exclusive and royalty-free. After the project, continued use require new terms, like licensing fee. This is non-exclusive, exclusive, and commercial. Slovenian Research Institute co-developed a patented sensor. The license is exclusively to manufacturing partner for EU sales. The license includes royalty payments on every unit source. Example of fair and reasonable licensing is partner request access to post-project foreground software to build a dual-use product. The owner agrees to license it at a market-aligned price, with limitations on field of use. Best practice, again, define licensing conditions early. In ideal situation at the proposal stage or before the grant agreement. Include terms which already exist in consortium agreement or separate licensing agreement. Of course, ensure licenses in respect to EU export control laws. In joint ownership case, define whether co-owners can license independently or jointly this ownership. And where relevant, define governing law and jurisdiction in cross-border agreements. What about subcontractors? You know that in EDF project, consortium often engage some subcontractors or third-party contractors for some specific tasks. This is sometimes essential, but on the other side, it can arise serious IP-related risk and legal responsibilities. which have to be managed proactively in advance. So, in the EDF context, we have three types of let me say, contributors which are not partners of the project. Subcontractor is actually one who performs specific tasks on behalf of beneficiary under control of the beneficiary. Third party is any external entity that is not part of the consortia, and linked third party is entity with a legal or capital linked to one of the beneficiary, like parent company. These actors are not consortium member, but may have access to some sensitive information or some co-developed IPR, which are the risks connected with that. Consortia can lose of ownership because subcontractors may claim rights to IP if contracts do not clearly assign ownership to the beneficiary. We can lose confidentially because subcontractor might disclose or reuse sensitive know-how. We can, it can happen that we got export control violations because some contractor may be located in third countries and they can create compliance issues. And ambiguity in IP contribution, unclear boundaries between subcontracted works and foreground IP can also lead to disputes. So, best practice to avoid this is to use robust subcontracting agreements. So, clauses have to include that full ownership of the results belongs to beneficiary or clarify joint ownership. Establish confidentially and non-disclosure obligations with subcontractors. Include limitation on further use or disclosure, and of course define access rights if the subcontractor needs background or foreground IP. This in the contract with the subcontractor, we should somehow reflect EDF grant agreement. So we have to ensure that subcontracting is foreseen in the grant agreement and the costs of the subcontracting are eligible and compliant with EDF rules. And subcontractors have to be somehow informed of the EDF project's IPR framework. Includes clauses that assign full ownership of the results to the beneficiary, establish confidentiality and non-disclosure obligations, and include limitations on further use or disclosure. Of course, it's important to include also access rights if the subcontractor needs background or foreground intellectual property. Finally, flow down of obligations. Actually, subcontractors should be contractually bound to comply with the same IP as the partner's main beneficiaries. Confidentiality, export control obligations, dissemination restrictions, classification, security and clearance rules, export control compliance, etc. Checklist, what are the key clauses in subcontractor agreements? These 6 points like IP ownership, confidentiality, no publication, export control compliance, access right limitation, and security clearance if needed should be involved in this subcontracted agreement with the adequate purpose, first of all, to assure that results belong to the beneficiary, not the subcontractor, to prohibit unauthorized disclosure, request beneficiary approval for any dissemination, ensures adherence to dual use and restricted destination rules, and restrict use of background IP to task-specific scope only. And of course, if needed, security clearance for defense relevant classified tasks. Example, Croatian EDF beneficiary subcontracts Slovenian software company to develop simulation model. Subcontract includes a clause stating that all the results are assigned to the beneficiary. Slovene companies must keep the software confidential, cannot reuse it outside the EDF project, and may not share it with non-EU entities. And before any demo or publication, the subcontractor had to seek approval from the beneficiaries. These are practical definitions which could be involved in this subcontracting agreement. It's good to establish internal procedure within the EDF consortia in order to review and approving subcontracting agreements, because many partners, many subcontractors, registering third-party involvement in project documentation, and to monitoring subcontractor compliance through reporting and audits. Any questions?
None in the chat. It is for you.
Let's go to the part 3. We briefly touch this IPR strategy in the morning session. Let's put into the scope of EDF project. So here we will talk about guidelines to develop and implement internal IPR strategy, which is aligned in the EDF expectation. Key topics here are aligning internal IPR strategy with EU and national defense framework, how to build an IPR management team. We will say some words about patent landscaping and freedom to operate analysis, about securing the IP before dissemination, about creating internal procedures for invention, disclosure, and secrecy levels. And the last point will be about IPR valorization, utilization, oriented toward licensing, spin-offs, joint ventures, etc. Let's first start with internal project IPR strategy with EU and national defense framework. EDF projects are very complex, and generic IP strategy is no longer sufficient. So, partners, beneficiaries, consortia have to align their internal IPR management system with the specific requirements, legal requirements, security requirements, strategic requirements, not only on EU level, but also regarding to national defense ecosystem. And this alignment ensures full compliance with all laws, EU and national laws, strategic protection of sensitive technologies, which is also part of the business strategy of participants, and the last, readiness for commercialization and security cooperation in the future, after the project will be finished. Why this is so essential? Of course, legal compliance, it's, let me say, important, because intellectual property have to comply with export controls, classification regimes, grant rules. So legal compliance is number one. Second is operational efficiency. because these procedures help to support project executions and partner collaboration, not to opposite them or make them inefficient or prevent them to work efficiently. So these internal IP procedures help to be proactive and help to support project execution. On the level of company or nationality as well, strategic protection of innovation have not only company value, but could also have national security value. In defense IP, of course, and these have to be protected from misuse. And last but not least, access to future funding. Because when consortial partner within the EDF project demonstrates their IPR maturity, actually this improves their credibility and eligibility, and also support evaluation scores in further EDF or other EU or national granted R&D projects. So we have 5 pillars of this defense-aligned IPR strategy. First is policy integration. This actually ensures the organization IP policy explicitly address defense-related R&D. These refer to export control, dual-use compliance, national classification law, and of course, secrecy protocols and control dissemination within the project and after the project. Second pillar is organizational roles and responsibilities. So to have appointed IPR officer or IPR team, which is responsible for registration, reporting, and licensing of the results of the project. Not only IPR officer, also security compliance officer, with the task to coordinate export control and classification within the project. And of course, technology transfer or commercialization advisors or advisor, which could be internal or external part of the project, to be hired to help the consortia and the partners to commercialize the project results in the best way. Contractual readiness. This IP clause should be aligned with EDF expectation on different levels. We already talked about subcontractors and supplier contracts, like IPR ownership, non-disclosure agreement. We shall not forget to employment contracts, which also have to consist some invention disclosure obligation after the projects. And licenses agreement, we already said exclusive versus non-exclusive, territorial limits, fair and reasonable use, etc. Fourth point is risk-based IP management. So when IP does matter? When it's properly managed. So we should conduct a regular IP risk assessment linked to these 4 points: security classification, dual use potential, foreign filing restrictions, or third country partnership. And we shall not forget that we all the time, it's never ending story. We should provide ongoing training to staff on IP basic, sector-specific issues, defense-specific disclosure, export control and red flags, reporting protectable results during EDF project, etc. Why always have this ongoing training? Because staff or persons involved in the projects are changing. Some people leave, another persons come. It's never enough training to the people in order to understand this topic. These are actually these five pillars of IPR strategy. We have some document which I will not go in deep to them to check like EU regulation about dual use controls, of course, EDF, MGA, European Intellectual Property Action Plan for Defense, which talking about strategic IP use in defense innovation, national patent and security laws in different countries, and of course some other directives of European Union which is oriented toward cybersecurity and data protection like NIS2 and GDPR. Example, Slovenian Defense SME updates its internal policy to include five. First, mandatory review of inventions for export control classification, establish notification procedures if an invention could be subject to Article 17, as we said, classified invention, include contractual templates for licensing with partners inside, outside the EU, and establish in-house IP log system aligned with EDF reporting requirements. Results: the SME improved its EDF project executions, avoid IP compliance risk, and position itself better for international licensing deals, not only in the defense projects, but in all projects and in all international business, which probably will have in the future. Practical actions. It's a repeat and update your IP policy, define internal roles, map your IP assets, establish procedures, ensure that your consortium agreement and licensing terms meet all EDF expectations, and of course, training employees, technical, as well as legal teams regularly. How to build an IPR management team. As we said, we do not need not just clear policy, we have to have operational capacity. This means actually multidisciplinary team that can manage full life cycle of intellectual properties, from creation, classifications, protection, compliance, exploitation. This cross-functional collaboration between technical, legal, commercial experts is very important. Why? Because of these high-risk and complex regulatory frameworks, and of course, strategic sensitivity. Why this is important? Important is for early identification of protectable IP. As we already said, engineers, researchers often lack this legal insight to detect patentable or confidential outcomes. Ensuring legal compliance. Navigating EU national security regulation requires legal expertise. Facilitating exploitation. IP have to be packaged, evaluated, and licensed. All these tasks require also commercial input. And of course, last but not least, avoiding disputes. Clearly assigned roles and rights significantly reduce legal risks. Possible structure of such a team. We said R&D lead or work package leaders, which are responsible for technical reporting of results and flagging potential inventions. IPR officer or legal counsel, which drafts IP clauses, manages filings, handles ownership and licensing. Technology transfer expert, which help evaluate marketing potential, negotiate licensing, support exploitation planning. Export control compliance officer screens technologies, ensure an alignment with dual use and sanction regulations. And security classification advisors, which coordinates governmental liaison if classified IP is involved. Here I list also key competencies which are required for these persons. First is technical awareness. So it helps to distinguish between different types of IP and understanding of innovation workflows in defense R&D, legal knowledge regarding IP law, contractual law, EDF grant agreements, articles, national security legislation, regulatory and security compliance, like export control, sanctions compliance, cybersecurity. And fourth, commercial and exploitation skills like technology valorization, market scanning, partners engagement, licensing models, and valuations methods. Of course, there are some tools and support mechanisms to support this process. One is to establish IP management platform, to involve external patent attorneys for drafting and prosecuting patents, national IP offices and ministries for advice on classifications, and of course, European Defence Agency and European IP Help Desk for strategic guidance on EU level alignment. Examples: Croatian mid-sized defense tech firm sets up a 3-person IPR task force with R&D manager, which flags new technical outputs every 2 months. A part-time legal advisor, which is outsources to evaluate protectability and draft clauses. And third is business development officer, liaise with end users and handles licensing outreach. These setups actually allow the company to file patents promptly, negotiate licenses, post-project and response to export compliance checks, all while avoiding delays and disputes. We said mid-sized company who established this 3-person task force. For the SMEs or the micro company, this is practically impossible to have separate person or persons or team who is dealing with that, but at least they can have one person who understands the topic, who understands the tasks, and who can ask for help or outsource the help in the case they need such a knowledge or such an expertise on the specific topic. Some tips for implementation. So where the capacity is missing, outsource or collaborate. It's a good solution probably to have contract with existing university, TTO, or patent company. At least define internal IP reporting workflow. And again, training technical and legal staff in EU defense IPR issues and document all decisions and project records. This is especially important where there is joint ownership case. Well, let's go on. Point 3, use of patent landscaping and freedom to operate analysis. For EDF participants, especially SMEs in the research organization and system integrators, it's very important to understand patent environment. So use tools like patent landscaping or freedom to operate analysis will help them to navigate this IP space and avoid infringement and position their innovation for not only protection, but also for the commercialization. As I am coming from the technology transfer office, I always said, maybe Maya will now correct me, but what the point of protection of the IPR? Protection of IPR makes sense when you want to commercialize it. If you not want to commercialize it in any way, it doesn't matter to protect it. So you go this hand in hand. Protection is actually first step for commercialization. These tools are actually indispensable when you're working in these security sensitive technology areas like sensors, autonomous systems, artificial intelligence, radar technology, encryptions, where there is a lot of competitors, a lot of actors, a lot of research in this field. So what is actually patent landscaping? Actually, patent landscape is actually analytical map of existing patents on one technological field. Why we do this? Because we have to understand who owns what. What is in the ownership of competitors, what ownership have collaborators, what ownership have our suppliers. Second, we want to detect innovation trends. So in which directions goes the research? Where are possible technology gaps? Which zones are probably already sectorized? We want to identify white space, so areas where there is less patents, where is more freedom. And this help us to support planning our research or development, to support our IP strategy, to support an investment decision. So here is not the question of research which is granted by public sources. Investment decision for post-project activities is much more costly. Key element of this patent landscaping are patent clusters in different technology domains, then geographical coverage. In general, United States, European Union, China, India, you said also, probably.
Well, now it keeps emerging, also depending on the type of the invention, but we've seen that they are really strong in computer implemented inventions in programming. So we may expect India is kind of an emerging country. But yeah, these are the most important, sometimes even Japan and Korea, again, depending on the sector, but those three are certainly the top countries with regards to coverage.
Okay, then we have this top patent applicants and assignees, who are the main players in the field, what are the field trends over the time. And the citation analysis is also a very useful tool because we can find out influence of these key patents. Also, how many researchers use it on their future research. Example. Slovenian SME develops advanced drone stabilizer, conduct a landscape study. And they discovered that most filings are concentrated in Japan and the United States, with a few EU-based patents in low-altitude wind compensation algorithm. So they found this as a strategic opportunity and start to develop these algorithms for that. What is freedom to operate analysis? So, freedom to operate determines whether your innovation can be used, manufactured, or sold without infringing on existing patents. We have to focus on valid, enforced patents and in target countries, claims which can overlap with our product and process. And of course, we have to focus on territorial scope of protection. Why? In order to reduce risk of legal disputes. Or probably we can decide to license third-party existing patents, or probably design our new solution around the patents. Support due diligence before entering new markets, and of course ensure compliance in dual use or security restricted applications. Example, partner in an EDF project is preparing to commercialize a new radar antenna design. And freedom to operate analysis showed that a similar US patent is active in Germany. The team contacts the patent holder for licensing or redesign the system to avoid infringement. So they have two solutions: to license the existing patent or redesign the system in order to avoid patent protection.
The selection of the strategy basically depends on how prepared the product is. If it's finalized and tested and appears to be market ready, and there is no way to redesign it, then it's probably best to ask for a license. And if the patent is kind of written in a sense that you can circumvent and redesign the product, which does not take a lot of time or a lot of financial input into it, then it makes sense to redesign the system to avoid infringement. So this really depends on the product's readiness and the partner commitment to the product.
Thank you. So how these tools support EDF project? Patent landscape actually informs early R&D decisions, help to align with the trends, avoids duplication. Freedom to operate analysis prevent unintentional infringement, supports clean commercialization, and both actually strengthen patent filings, identify partners or acquisition targets. But just a note that these tools are not legal guarantees, but it's risk assessment instruments, which is used for decision making. Best practice, said that before or during the EDF project, conduct landscaping to define your innovation niche and avoid crowded IP zones, and to identify potential joint ownership risk with overlapping third-party patents. Before dissemination or exploitation after the project finished, have to analyze this can help us find some risk, like how to act if we find this risk that are existing. So, like, consider design arounds, to seek licenses, or file for opposition or invalidation, which is more or less a theoretical, or it's very rare case that you opposite some patent file.
It's probably more rare, but still it's a valid and usable tool in order to get a patent revoked, or even more specified. If it gets more narrow, then maybe it will be easier for you to redesign your product and avoid infringement. So this is what has to be kept in mind, that if you have an opposition period open, then you can file for opposition, or you can request invalidation at courts. But yeah, these are kind of rare cases, but are still available, and invalidations at courts, they may be expensive, but it may be worth to invest in those processes as well. Particularly if you know the prior art, and if you have really solid proof or evidence that the patent was not validly granted, because such thorough FTO analysis may end up with more prior art than has been cited in the patent grant procedure. So you may have something that's really of value.
Okay, there are some tools and resources, some public databases, professional tools, or legal advisors, or patent attorneys, which are used for claim interpretation and formal opinions. So, if we make a short overview of this process, we start with the landscape mapping, we identify players, strengths, and, let me say, some places for our activities. Second, we have internal IP review in order to match our inventions to external claims. Freedom to operate search to examine blocking patents and in target markets. Legal interpretation. So if we are in doubt, or we find some overlapping, always seek for professional guidance to help us what this means actually. And the last is action plan. So, or license, buying license, redesign our invention, or proceed with the protection. Example, in case of EDF, consortium working on quantum encrypted communication in EDF project. And they discovered during landscaping that several United States and Chinese firms dominated the patent space. So they conduct an FTO analysis and realized that a specific key exchange method is already patented in the EU. So the R&D team alters its protocol, achieving novelty and avoiding legal exposure. We mentioned this, I think, many times today.
Yeah, but it's really important.
But it's really important, it's really important. Please secure IP before dissemination. Especially in the EDF project, this need for dissemination of results, even through reports, publications, public communication, etc., have to be really carefully balanced against the requirement to protect intellectual property rights, maintain confidentiality, and uphold national or EU security interests. Why this is repeated so many times? Because the consequences of failing this can lead to loss of patentability, breach of confidentiality clause, exposure to foreign exploitation, non-compliance with EU grant conditions, and consequently consequences of every of these 4 points are very bad for the company. There's a very strong effect on the reputation, financial effect, the negative financial effect, etc. Even legal consequences could arise. So, dissemination EDF contact actually means what means? This means sharing project results with the audiences outside the consortium. And this includes everything. It includes scientific and technical publication, conference presentation, press releases, promotional content, demonstration events, even reports to Cordis or EC portal. Nation is part of the project. It's one of the essential part of the project. We have to disseminate our results, but only after appropriate IP protection measures are taken. Again, premature public disclosure means loss of novelty. There is no revoking, we said, we cannot file for patent anymore. Unprotected data sharing. So, third parties may use results without permissions. Violation of grant terms can lead to loss of funding or financial penalties. And of course, security compromise, this exposure of classified or dual-use data can to unauthorized actors. So it's always good to check these steps before dissemination. First, check for IP value. Is this protectable via patent, design, copyright, or trade secret? Has an invention disclosure been filed internally? Second, consult the IPR or legal team. Is there protection in place? What is the status of ownership or co-ownership? Conduct security and export control review. Any information is classified or export control. Redact or restrict part of dissemination material if necessary. Notify partners in advance. Again, everything is good to be communicated in advance. Consortium agreement typically requires notice about 30 days before dissemination, and partners may object it in the case that their own IP or commercial interests are in threat. And of course, mark dissemination output appropriate. So whether this content is open access, confidential, restrictions, and of course, acknowledge EDF funding as per the grant agreement. Main rules in the EDF grant agreement here are: 1. Beneficiary must take measures to adequately protect results prior to any dissemination. And Article 18 requires notification of disseminations to other beneficiaries in advance, typically via internal procedures within the consortium. Failure to notify or protect may lead to funding clawbacks or ineligibility of IP for exploitation. So again, consequences are very bad. Example scenario: partner in an EDF project prepares to present a new signal processing method at the defense conference. Before the presentation, their IP manager reviews the content and identifies a patentable algorithm. A patent application is filed, and the publication is postponed by 3 weeks in order to secure priority date. Other partners are notified, raise no objections, and the final presentation includes only non-sensitive details. Probably you can add this. It's a very good point when you are dealing with the researchers and their publish or perish mindset. Just to postpone this publication for a specific part of time, which allow us to file a patent or some kind of protection.
Yes, this is an example of an ideal scenario where the IP manager reviews the content and says, okay, you can present, but wait a bit, so the application gets filed. And it's always wise to include non-sensitive details and to avoid presenting any sensitive details or particulars of the invention or any other parts of the solution. So yes, this is something that we should all aim for when making such presentations.
Best practice: integrate IP review checkpoint, maintain dissemination registry with logs of approvals and objections, set internal deadlines to align patent filings with publication schedules. Again, train researchers on what not to disclose before securing, and use redaction protocols for public versions of technical documents. Okay, next topic. How to create these internal procedures for preventing mutual disclosure and secrecy level. Actually, in EDF-funded projects, we have to, on the organization level or on consortium level, implement some internal procedures for invention disclosure and classification of sensitive informations. Why we are doing this? Because these procedures ensure us to timely capture and evaluate possible new IP, to protect of confidential and security relevant informations, and to comply with national secrecy laws and EDF grant conditions. These help us to be ready for patenting, licensing, and controlled dissemination. It's good to have on the organizational level some kind of invention disclosure form. With at least these 8 points of content. This means title of inventions, which describe the technical working title, inventors details, names, roles, and affiliations, project context, which work package, which task, which deliverable linkage, technical description, what was developed, how it works, what problem is solved, novelty and prior art analysis, which summarize why the idea is new, with prior work references, commercial and defense relevance, so potential use cases, dual use potential, date of conceptions in order to establish priority in inventorship, and proposed protection rule. Is this patent or probably trade secrets, copyright, or undecided? And this document should be treated as confidential document and stored in a secure place. Why this is matter? Because we often involve some sensitive dual-use defense-specific innovations. So we have to classify this internal documentation in order to control access and to ensure compliance. So probably some security levels proposed here are like public, like EDF project public, which is free for dissemination, confidential for internal use only, which is limited to project team or indefinite or narrow defined groups, restricted access with NDA only, which is limited to cleared individuals under NDA, and the higher level is classified, national defense classified, which have to be handled according to the national security rules. Example, Croatian Defense SME defines the following internal procedures. R&D team identifies a potential inventions. Inventor submits an IDF to the IP officers within 5 days. Legal teams review this IDF for novelty and patentability. If valuable patent filing is initiated, document is marked with restricted, pre-patent, and dissemination is paused. Once patent is filed, the result is reclassified as confidential and can be presented externally. That is simple internal procedure which can be adopted even in SME, which clearly set a path of the potential inventions in order to be protected or not, and in order to be disseminated or presented or not. Key documents for this part, so invention disclosure form, which capture and records new inventions, which should be confidential and available to IP team only. Classification guidelines, which set levels of information sensitivity, and is controlled in company, wide training and compliance. Secure IP registry, which track inventions, status of these inventions, and ownership of these inventions with limited access in encrypted storage. And internal dissemination log, which show us which documents was shared to whom and when. It's have to be reviewed before external publication. IPR valorization, licensing, spin-offs, joint ventures. Goal of the EDF project is actually not commercialization, but it leads to the point when commercialization become an issue or actual. And question here is how to transform this innovation into strategic and commercial impact. This actually go beyond protection because it go to actively exploit the results of the project and how we can exploit the results through different ways. One is licensing, technology transfer, spin-out creations, or forming some strategic partnerships or joint ventures between the project partners. Because a lot of EDF outcomes have relation to dual use of defense-specific technologies. So we have to make this valorization in accordance with export control, security policy, and national interests. So, what is valorization? Valorization is actually a process which turns protected innovations into value. Whether economic, revenue, or strategic revenue. So, we said, we can occur this through commercial licensing, non-exclusive, exclusive, we already mentioned that, internal exploitation, like to develop its own product, spin-off creation, joint venture or strategic partnership, and open innovating licensing.
I'm sorry to interrupt, but Bruno has raised his hand.
Sorry, Bruno, yes?
Hello, can you hear me?
Yes?
Well, I just want to give you some break to take a breath in. Wow, you're really professionals. I mean, there's no way I could do such a long presentation and keeping up with all the information that you give us. We are almost out of time for today. And I remember you have like many more slides to go. So perhaps we can wrap it out for today and open up some discussion. If you want, Aleš, to finish up with something that you find the most important out of the slides, perhaps you can take 5 minutes or so. We are very scarce in numbers for today. So during this next meeting of EOA project, I would propose to maybe do something more about the IPR in the upcoming events in the live workshops, because I think the topic is very important and you obviously have a lot of experience in covering it. So do you mind maybe to have the closing remarks, and perhaps anyway we will share all the information from the slides to everyone. We are all a little bit tired. I don't know about you, but we are here at 35 or something degrees with very sunny day and it's very warm. But in any case, if you could please wrap it up, and maybe we can have a small discussion if there are any questions, and then hopefully we'll have some more time, because I think this topic is very important for NFPs, and we need to bring them closer to them as much as possible. Thank you.
Okay, thank you, Bruno. So if you agree, we have a few more slides just to conclude the part 3.
Of
which
course,
is
yes.
this is the last question of this IP valorization. The part 4 is oriented to our GDPR and NIS2, so this could probably left for let me say for its own reading, and the last slides are oriented toward, let me say, main takeaways, which we also can skip and could be read it later on. So if you agree, please allow me a few more minutes to finish this part 3, and then we can open floor for the questions and possible some clarification. Is this okay for you?
Yes, thank you.
Okay, perfect. So licensing. We already mentioned that the IP owner grants usage rights to another party with or without exclusivity. In the defense context, this licensing to the systems or integrators of the ministries of defense or NATO suppliers can include technology packages like documentations, training, testing protocols, and requires strict clauses on export restrictions, field of use, and non-transferability. Example, Slovenian SME develop unique heat signature masking material. It licenses the IP exclusively to a French prime contractor for integration into stealth vehicles under NATO-only use restrictions. Spin-off creation. Spin-off creation means to establish a new company in order to exploit one or more project results. In this spin-off actually allows commercialization outside of the consortium core operations. This spin-off creation is often supported by a public R&D commercialization, like EIC transition program I already mentioned, or national innovation funds. Of course, we have to arrange ourselves right to use. So this spin-off creation requirement, clear IP assignment or licensing, defined ownership structure, and of course, strategic alignment with national defense authorities in the case of sensitive tech. Example, research team with Croatian University develops secure communication protocol during an EDF project. They launch a spin-off company to deliver secure battlefield communication solution for civil protection agencies and NATO peacekeeping forces. Third path for EDF IP valorization is joint venture, when two or more entities create a shared business structure in order to develop and commercialize results. It is used where combining complementary capabilities. For example, one partner owns one kind of intellectual properties, and others have a production capacity or market access. And this is often used for long-term defense system development or scale up the company. Key intellectual property considerations which we have to take into account to this is joint IP ownership structures and contribution evaluation, governance over future intellectual properties developed by the joint venture, and of course, security clearance of all joint venture partners. Example, German integrator and Croatian electronic SME jointly established a joint venture to manufacture and export counter-drone radar system derived from EDF project. Intellectual property from both sides is licensed into the joint ventures, which is subject to strict dual-use export control. Compliance and risk mitigation in valorization. So we have 4 existing risks like export control breach, IP misuse or leakages, infringement on third-party intellectual property, and misaligned expectation in joint venture. So mitigation approach is listed on the right side. Key steps we can skip. And this is summary table for more valorization models, which actually summarize the things I already say before. Maybe the last point for this part is IP bonding and portfolio planning. I will just summarize all the slides here in order to maximize commercial and strategic value of EDF results. It is useful to bonding intellectual properties and plan and portfolio as a strategic tools for licensing to ensure critical IP components are aligned and position the innovation for commercial uptake and mission-driven deployment. What is IP bonding? What is portfolio planning? What is example? Maybe example which showed the right picture. EDF project deals in a patent signal processing method, which is 1 patent. We have source code for a detection algorithm, which is copyrighted. And we have 3D antenna housing design, which is industrial design. And of course, we have calibrating data set, which means data intellectual property. Bundled together, this form marketable radar module for both or civil aviations or military ground units. Without bundling, all these intellectual properties would be fragmented. Licensing is almost impossible. Valuation is unclear. And of course, commercialization is very delayed. Okay, portfolio, dual-use specific risk and mitigation, implement tips and takeaways, which could be read later on. Thank you very much for your attention. Please, if there is some questions, please just go on.
Yes, I think there is one hand raised. Ernesto, you have the floor.
I'm sorry, I had my micro closed, so I was trying to say that and the first is to guide to express my grateful for your work. Has been a very interesting explanation and a hard issue for us. Sometimes it's very complicated to understand all the implications that this question have for our projects. So thank you very much for both. And my question is more a reflection than a question. I have been involved in this kind of projects from the start, from the 2019 edition of the EDIDP projects, and in charge of the office in the Spanish Ministry of Defense, in charge of negotiating MOUs that we need to put in place among the countries to arrange our finance support to these projects. And I think that you have mentioned several times, or a lot of times, the grant agreement and also the consortium agreement. But in this scheme, we have also the contract, of course, among the nations and the industry, and also the MOUs. We, in the MOU, you are probably aware that we are asking for right of uses for defense purposes, because that was the only possibility that we find back in 2019 when we started to negotiate with the industry. But this recently we are having evolution in these requirements, because the projects are having subsequent phases sometimes, and it's getting more and more complicated, this issue. And at the start, right of use for defense purposes of the total result of the project seemed to be an easy question, because at that stage the projects were most of them were in a TRL very low. So the industry didn't pay a lot of attention to these requirements, because they were willing to receive the grant. So that was the easy. But now we are facing problems, because the projects in subsequent phases, they are reaching a higher level of TRL, and the funding provided by the nations are increasing. So I foresee that in future we are going to be discussing a lot about this kind of issues. So it's very interesting your support here, and I would like to ask you if you, in your opinion, in the grant agreement, not in the grant agreement, in the consortium agreement, the industry should establish that they should negotiate with the nations in exchange of our support, because sometimes we find that one of the companies that doesn't receive support, for example, for their nation, can be very reluctant to give us the results that we are asking for. That's my question. I don't know if I have spoke too much, but I don't know if my question is clear, but I could clarify you if you need. Thank you.
Oh, thank you very much for your question. If I understand correctly, even now, when the companies are applying for the EDF projects, they need some kind of letter of support, which is almost pre-order from some national ministries of defense.
Mm-hmm.
And this means that some kind of this negotiation already exists. This is somehow separate from the grant agreement, from this general grant agreement. This is one point. Second point, what I see, I'm not so long in EDF projects as you, so it's 5 years, I think now it's fifth iteration of the EDF call, I think, open. I'm involved about 3 years. What I see now is that the EDF projects have, as you right said, goes to the higher TRL levels, and there is much more points oriented toward this commercialization. And also we have new path or new tracks that you can start from the let me say civil projects and goes to the defense project. And on the other side, you finish the EDF project and you can apply for EIC transition or EIC accelerator in order to commercialize it or to scale up it or something like this. So I think I see this trend maybe in last 2 years very strong, and there is another point. EDF is one instrument, but within the EDA we have these instruments as well, like accelerators and other another opportunity for the companies who decide to go there. And we have also this Diana accelerator, which is, let me say, some kind of NATO counterpart of EUDIS accelerator. I see all these initiatives and programs are not to have a right word, not want to say not harmonized yet, but I think that on the beginning of its path, in that they have to be developed in the future on the right matter. And as you said, companies, when the companies start to negotiate with the national MODs, how to include all the players, let me say European Union, NATO, and the national ministry will be quite, let me say, demanding task in order to harmonize everything. I don't know if I answered your questions, but at least I think that I catch your concern regarding that.
Yeah, in fact, I think there is not possible to give an answer. As you said, we have facing a lot of changes, a lot of initiatives. So we have a lot of work in front of us. So as I said, but I think, in my opinion, this issue about the IPR will be a key question. So thank you for your explanation. Thank you.
Thank you for the question.
Is there any further question, maybe? There's nothing in the chat. So
Marco, Bruno,
do you have anything?
what do you think?
Before we finish, I would just like to thank you, first of all, for your presentation. But before we finish, I would like to ask the participants for just a few more minutes of your time to fill in a satisfaction survey. That will be really helpful for us and for the presenters, and for us also in preparing future workshops. I will leave the link for the survey in the comment box. It only takes maybe 2 or 3 minutes, so we would be very grateful if you could fill it out. Thank you.
Okay, Marco, since there's not so many people here, I will also ask you to share it with me, and I will send it all the participants that I have in my mailing list.
Yeah,
So
sure.
they can fulfill and send it to us in some due time. That's also fine.
Yeah.
Okay.
The link is in the comments. Okay, basically that's everything. Bruno, I think we can wrap it up.
Yeah, we can wrap it up. Once more, thank you very much, Maja and Aleš. This was overwhelming information for the NFPs, but I think this will not be the end of the talking about the IPR. Thank you very much. And Marco, thank you also.
Thank you.
Thank you very much also from our side to all participants and to you for organization this event, and have a nice day and successful.
Thank you.
Thank you
Thank
also
you.
from my side.
Bye.
Have a nice
Bye-bye.
day.
Yeah, thank you very much.
Bye. Goodbye.
Bye.
Goodbye.